Not matter. This study I made because your lot is to move that application not unlisted. And after getting me, your lot is directed to file the filing section and give a number. And the matter will be taken on Thursday. Thursday, my lord, application will be started. And therefore, my lord, it is a very urgent matter, my lord.
What is the urgency?
Urgency is, my lord, behind back of the petitioner. My lord, SDO had passed the order of demolition. My lord, if it is not taken up,
It is appealable order. You challenge it to appeal before the district magistrate. SDO's order is appealable under the Act.
Appeal has been preferred and appeal has also been, my lord, dismissed. And therefore, my lord, the petitioner, my lord, without hearing everything, without demarcation, my lord, they have, my lord, passed the.
Very well, give it. I shall see if it can be accommodated.
Kindly, my lord, we think Wednesday.
Give it. I shall try.
Lordship. Lordship, may I
have written the grounds of urgency in your.
Yes.
May I kindly mention, my lord. May I pray, my lord? Item number 30, my lord. That can application upgraded, my lord. That may be, my lord, little higher, my lord, on the board Monday, my lord. May I pray, my lord? Because maybe there are some, your lordship, matter fixed perhaps in Monday, my lord. 30, my lord. That can matter, my lord. 30, my lord. That push.
Item 30.
I am praying, my lord. Little higher of the.
Give a slip. Give a slip. Don't.
I am writing.
Give a slip so that it can be upgraded. Mention your grounds.
Maybe.
My lord.
May I be permitted to mention a matter, my lord? There's an order which has been uploaded on the additional tab, my lord. Pursuant thereto, which went unnoticed. Pursuant thereto, there's a recovery notice which was issued, and my bank has been attached. And what's the best part is that this order is merely on account of a clerical mistake, against which a summons notice was issued way back in 2022. I appeared, and an order has been passed accepting my submission that no tax is payable. On the same issue, they pass an order, upload it on the additional tabs, no hearing, nothing granted. My recovery notice issued, my bank account has been attached. I've been forced to close down my business, a very small operation, my lord.
Please give it.
May I tell
you? Egulo sab urgent debe. Sonde bele dekhi nebe.
May I tell?
The matter for my lord's urgent determination. I don't think this matter by already possession of petitioner's property till 9 I don't think this order is expiring.
Today, then why are you mentioning today? How can I bring it in the list today? No. You have to serve the other side, has to appear. It can't be done like that. You should have mentioned 2-3 days earlier. Every mentionings are being taken up. It becomes difficult because it will appear on Monday, not before that.
My lord, my lord, may I be permitted to mention, lordship, today's list item number 620. And another is Occupants Act. My building will be demolished unless your lordship hears this matter. It's very urgent matter, small matter. If your lordship takes us on Tuesday at the top.
What is the order under challenge?
Actually, the notice has been given to me wrongly. Some next shop has to be given the notice, but my notice has been given by the municipality against to me. So they will be executing.
Give write a mentioning slip. Write the grounds of urgency. I will see it in my chamber.
Yes. Okay, grateful.
Yes. I have been informed by the officer that this matter has wrongly listed on the docs. Correct case number is WP 583 of 2023, but instead of 23, it's 24, and accordingly, cost title has been changed. But actual cost is Shiva Chemicals. Similar, this matter may be listed from the person, and at the time of call, I shall delete. That can wait, because before the vacation, all those matters, if they clock the list, then attachment and other proceedings will stop. That can wait. After the vacation you mentioned, I'll take it up. Yes.
The Lordship mentioning for extension of stays expiring in December.
Yes, please.
My lord, 2 matters for the inclusion.
Please give.
Lordship, may I be permitted to mention
a matter, Lordship? I mentioned this matter yesterday because it's a matter pertaining to cash seizure of 1.39 crores.
Yes.
The Lordship was pleased to allow the mentioning and directed that this appear as urgent.
Not appearing.
The Lordship is appearing as item number 498 of today's. This could be upgraded.
দেখুন
or
ওটা
taken up
ফোর
as-
নাইনটি এইটটা আর্জেন্ট মোশনে দিয়ে দেবে।
Gotcha. Great.
May I be permitted to mention, Lordship, this writ petition relates to the public premises eviction of unauthorized occupants. Previously, this has been heard by Honorable Justice Hiranand Bhattacharya on 1st of December 2025, and due to lack of determination, Lordship, this matter has been released. So I'm, yes.
Give it, it will appear. নিয়ে নিন।
Well, may I hand over the slip, my lord?
প্লিজ হ্যান্ড ওভার।
That
দেখুন এটা
modification can,
আর্জেন্টে আসবে, একটা আর্জেন্ট হিসেবে দিয়ে দিন, আর্জেন্ট মোশনে আসবে।
today's item number 30.
ইয়েস।
My lord, may I pray for leave to file and move urgently, my lord? This is a order of provisional attachment, my lord, which has been issued against me. My lord,
You file it, serve notice, no other urgent motion, no unlisted motions. File it, give notice, give the slip, call করুন please.
one. এটা কি জলপাইগুড়ি? Oh, sorry.
This matter has been mentioned for correction.
I have had,
25.
I have had.
Your Lordship, in Jalpaiguri, item number 1, I just entered. I believe your Lordship has passed the necessary order as the order dictation was in process.
Yes, has been done.
Gratefully.
Your Lordship, I'm appearing for the petitioner. I'm praying for withdrawal of the writ petition, Your Lordship. Here's the written instruction from the client, Your Lordship.
The deal. Instruction.
Lordship, I'm appearing on behalf of the petitioner. This is coming on my instance, Your Lordship. The interim order is expiring on December 2025, till the end of December 2025, Your Lordship.
The affidavits are complete. Followed it is the challenge to the show cause notice received. Oh.
Subsequent adjudication order.
And subsequent adjudication after the issuance of the first show cause notice, Your Lordship. First order, Your Lordship.
The petition was entertained on the followed it went up to the division bench. Thereafter it was
Division bench
granted trustee and remanded.
I have the, Your Lordship, if Your Lordship requires the
For a fresh consideration. Very well. This repetition, this matter.
My lord, I beg to appear on behalf of the petitioner, my lord. Interim order granted by your lordship is, my lord, valid till 31st of December 2025. Your lordship has passed the order on 13th of November 2025, my lord. Lord, I was appearing for respondent numbers 6 and 7, my lord.
Lordship, I am appearing for respondent number 3. There's a technical issue with my camera, Your Lordship. I'll just be coming in.
I'm appearing for the enforcement.
This requires to be heard out. No?
Yes, my lord. Yes, my lord.
But we are there for 10 to 12.
All the parties are here.
I appear on behalf of the respondent number 90.
Most of the contesting parties are here.
After reopening, we'll
My lord.
take it up for hearing.
My lord.
Conclude hearing. Likeni, this matter is appearing under the heading extension of interim order upon being mentioned therefore, full stop. Heard learned advocates appearing for the respective parties, full stop. The interim order which is subsisting and which is to continue till the end of December 2025 stands extended till the end of February 2026, full stop. When can it be fixed?
Any day, as per your lordship's convenience, after vacation.
Suggest a date so that I can take it up on
19th, my lord. Subject to your lordship.
19th will be Monday.
My lord, any Friday, I think, after 2 p.m. probably.
16th order.
This matter for hearing on January 16th,
My lord.
2026.
If it is fixed at 2 p.m., my lord, because it's a very matter does not
Time
come.
I'll not fix. I'll fix time once we see the determination.
Very good.
If there is a change,
My lord.
time won't.
My lord. Great. Great.
Before the last week, kind of my own, it was not recorded. I have
Give your name. It will be.
Yes, I.
सबर नामটা দেখে নাও।
I'm for the petition.
Well, the interim order is about to expire on December 25.
ওই affidavit are complete.
Yes, my lord. In this matter, affidavit
ওই
is
প্রথম
complete.
অর্ডারটা যা হলো monthly list of January and till the end of February.
a similar order may be passed.
ওই সেম এজ আইটেম 1 আর মানে প্রথমটা ছিল যেন সেম এজ আইটেম 2
In this matter also, the similar order may be passed.
For the CGST authority, my lord.
CGST is the answering response.
affidavit in reply has not yet been filed, I think.
No, my lord. Affidavit in reply has already been filed.
We have filed opposition, my lord, on 27 November.
Opposition is there, but reply is not there, and there is an office report saying reply is not there.
Reply টা দেখো হাতে আছে নাকি?
My lord,
এটা কি?
এটা পরেরটা।
Reply is not there in fact.
এর নামটা কি?
On in this November 24, there was an extension of time slot, but
My lord,
thereafter
we
there is
have
nothing
already served the accredited reply upon the
but
respondent.
there is
But
nothing in the file that
then,
there
my
is an
lord, kindly give me
there is
some
an
time.
office report of 18th of December saying that reply has not been filed.
My lord, then, my lord, kindly give me some time so that I can file the accredited reply because I have not holding the brief. My lord.
লিখে নিন তো ওই this matter is appearing under the heading extension of interim order.
My lord, in item number 7, my lord, the interim order is about to expire in
Same
December.
here also reply
And my
is
lord,
not there.
only thing that affidavit in opposition has not been served upon in this matter.
Not served, but fine. No, you took time for filing affidavit in reply. 27th March 2025 order says, on the prayer of the learned advocate for the petitioner, time to file affidavit in reply is extended by a period of 4 weeks. And here also lost Xerox copy and server. If something like that happens. Why that? The opposition is also not there. Opposition not there? No. Their opposition totally. Then it was wrong. We are also not.
2026 opposition. Thereafter, it was not filed, my lord. My lord, if I kindly look at order 28/18/2024, this was time to file the affidavit in opposition, my lord. Thereafter, we didn't receive that.
না তারপরে তো 27 দিন 25 দিন।
The affidavit in opposition, affidavit in reply, nothing has been filed.
My lord,
Last chance was given to you on February 28, 2024.
Another chance after the last. We'll file 1 week after vacation will file.
लिखे नहीं Opposition has been filed. Your reply is not there.
my lord,
ওই প্রথম লাইনটা সেম থাকবে সেম affidavit in reply to the
my lord, that in this matter,
reply opposition, nothing has been filed.
opposition has not been this.
Yes, Mr. Chakravarti.
So, I know it's embarrassment 2023.
Yes,
Will complete my.
I'll give last chance because this is
We have inherited about 1,000 papers.
do it, do it. Enjoy the inheritance.
Lord, the interim order is about to expire in 25, and the issue is I have challenged the notification issued under section 168.
Central is the.
No, the
When will you find?
I'm not answering this one.
The really end will not be for that. Before
4 weeks from now, we'll find out.
Mr. Rai, learned advocate appearing for the respondent CGST authorities. এটা তো order দিলাম শিবা কিন্তু
Lord, in next matter, item number 11, I was mentioning before your lordship.
yes.
Lord, there was a typographical error. Lord, it should
So
be
this matter will appear on Monday then because it's
my
not
lord,
in
my
the
lord,
list.
my lord. Lord, can it be fixed on Tuesday because Monday I have a small difficulty.
Somebody else will there.
My lord,
For extension
my
of
lord, my
interim
lord, my
order.
lord, my lord, my lord. As your lordship.
এটা সোমবারই দিয়ে দেবেন সোমবারই দিয়ে দেবেন আর এটার
I'm grateful, my lord.
Yes.
This is my senior will join.
What is your matter?
Matter is about this Beldang municipality. So my senior will join my lab.
When will you join? It's already 11.
Well, I take over the state response. Well, they have challenged the order at page 41. Page 41. This is the order under the section 4 of Unauthorized Occupant Act 1962.
But this is appealable order.
Yes, they have filed the appeal, but if your lordship may wanted me to say so, my lord, the appeal is not yet born because the section we applying is out of time also.
So then the appellate clerk will consider the appeal, whatever it is there. If
But
it is,
because he has to file application also, because otherwise it won't be taken on board.
My lord, can you give me a short pause over? Please, madam.
So,
pass over. Specially assigned matters.
My lord, in this matter, my lord, direction was that I served the copy, and as well as my lord, I personally meet with Mrs. Susmita Chatterjee and served the notice, stating all the facts. But your lordship, remember that matter. I am the daily wages worker, but the officer concerned willfully and intentionally, my lord, sent 60, 50, 70,000 rupees in my account and forcefully ordered me to withdraw it and deposit it. I have done it. But henceforth, while I have objected it, they have, my lord, not allow me to continue my daily work.
My lord, I am appealing for the previous content. But my lord, in this matter, Mr. Shomnath was appointed as a senior, my lord. And one, my lord, he, as per my knowledge, my lord, he resigned from the panel, my lord. But some time, my lord, I have no date or brief instruction with him.
When will you? Because this matter has been pending since long. Nobody was appearing.
Well, one prayer, I am not praying any interim order. Only one prayer, kindly direct the Director of Forest Government of West Bengal to dispose of the matter, take into account all the officers to present and represent, because the must
Let her come with instructions.
One request, my lord, one copy may be served again, my lord.
আমি দিয়ে দেবো তোমাকে, কোনো প্রবলেম। তাহলে
লিখে নিন।
6 তারিখে তুমি করবেন, ঠিক?
Miss Chatterjee, learned
Yes, but I'm in the next point. But I'm for the petitioner, my lord. Upon your lordship's direction, my lord.
We are for the union against.
Upon your lordship's direction, my lord. Copy was served, my lord, and the correction was made, my lord, in the cost title, my lord. and copy was also served. Your Lordship on the last occasion was pleased to, my lord, note that despite, my lord, orders of this honorable court, my lord, that they are not appearing, my lord, the Calcutta telephones.
Who is appearing for Calcutta Telephone? Calcutta Telephone Cooperative Committee.
Was served copy on the special officer as well as, my lord, on the organization as well.
This does not show where it has been served, where it shows service at Kolkata GPO DC.
Well, on the last occasion, my lord, I also, my lord, filed a affidavit of service. That was, my lord, on the special officer. Only on the special officer, not on the organization, my lord. The same address, my lord, track report, my lord, shows, my lord, that item was delivered.
They don't appear to be delivered. In the last one, which you sent, it does not appear to have been delivered.
My lord, may I, my lord, একবার সাথে বার affidavit বার করে দেবো তো। My lord, may I,
I've seen the affidavit.
But Calcutta telephones, my lord, there is only, my lord, this 8 Hare Street, my lord, that is the only address of Calcutta telephones, my lord.
It's not Calcutta Telephones, it's Calcutta Telephones.
Yes, yes, my lord, Calcutta Telephones District Cooperative Limited.
Yes, so don't say Calcutta Telephones. What was the issue here?
Issue, my lord, was that a policy, life insurance corporation policy was, my lord, submitted, my lord, before the authority. Now, my lord, for
it was assigned before the Calcutta.
it was, they say, my lord, that it was assigned before the Calcutta telephones. There was an issue, my lord, that once upon a time, my lord, the deceased, my lord, he to avail the loan, my lord, from this district cooperative. My lord, Calcutta telephones would be, my lord, in the best position to say, my lord, whether the loan has been, my lord, that has been paid off. If it has,
what is the document with you to show that you have paid off the loan?
well, that is the reason, my lord, I say that, my lord, the original policy was handed over to, my lord, to the life insurance corporation. If the original policy was, my lord, handed over to the was in possession of this, my lord, this petitioner, then, my lord, it could not have been the case that the policy was assigned. Or, my lord, it might have been assigned, but it has been returned back upon completion of payment. Lordship kindly sees, my lord, page 14 and, my lord, page 13. page 14, my lord, I say that the original policy bond of LIC policy number such and such is, my lord, submitted to the branch manager, and page 13 is the receipt that I have received against the, my lord, the said.
Page 13.
Page 13, my lord. The receipt that, my lord, the LIC has taken the original policy.
Page 13 is the receipt of the claim form. Doesn't show that original policy.
My lord, kindly see, my lord, received from, my lord, policy bond number such and such is the first line. Policy bond number such and such, the certificate.
Policy bond number is given. It doesn't show that the original policy has been received.
Kindly, my lord, comes to page 14.
Page 14.
Okay, page 14, the last line.
Here.
The last line, my lord, such and such these documents are submitted by the last line says original policy bond of LIC policy number such and such to settle my claim. And when I submit this, I get, my lord, the page 13 receipt.
This page 14 does not contain any receipt.
No, my lord, cannot be, my lord. Since, my lord, this page 13, my lord, they have, my lord.
Only in respect of policy bond, only in respect of the claim form. Receipt is only in respect of the claim.
My lord, policy bond is the first line, my lord. Kindly see. The first line says
policy bond is not the first line. Policy bond number is the first line. So this is a claim in respect of that policy bond number. Don't explain that way. Policy bond number is given. That means your claim is in respect of that policy bond having that number. That is the meaning. It doesn't mean that the policy bond in original has been submitted or.
My lord, may I humbly submit, my lord? My lord, policy bond, there is a signature, my lord, there is a tick mark against that policy bond, after which the number is given. Until, my lord, the original policy bond is submitted to them, my lord.
This is not how we interpret that.
This is, my lord, this is, my lord, what is my instruction is, my lord. Upon, my lord, without, my lord, submission of the original policy bond, they, my lord, LIC will not, my lord, take my claim into account itself.
They have not taken your claim into account. If they had taken your claim into account, they would have given it. It's not your case that they have not received the document or they will not receive the document. They have received the document, but they have, for reason given in the report, they have not found it good enough. देखो तो Where were you? Please wait. You may mention it for urgency, on urgent grounds, then you are unavailable when the matter is called on, then you suddenly come up and you want it to be taken up, then you have to wait now. If you have any matter, go and do. If I call and you are not there, I will not pick up, because this is not the right way. Come back at 12. 12. Yes. Yes.
Regarding that, I have three submission, kindly comes to page 101. This is the order of the blacklisting that was challenged by my learned senior.
Page 101.
101 and the 102, kindly the top, whereas it appears both the ADM and TLR of Purulia and Purbo Bardhaman issued so-called notice to Atta and substantial for substandard performance. And whereas it appears the reply submitted by the TGIS was not accepted by the such and such. Now next, whereas it appears the ADM and TLR of Purulia Purbo Bardhaman had terminated the contract on the ground of non-performance of petitioner. And whereas it appears, I am on this, whereas it appears that unprofessional attitude has caused this office resources and valuable time, putting whole issue public service delivery in the concerned Mauja is totally jeopardized. Therefore, considering all the issues mentioning above, PCTGIS is hereby blacklisted for taking up to participate any kind of work under this directorate for a period of 3 years from the issue of this order. Now, in this issue, I am relying on judgment passed by this Honorable Court, Honorable Supreme Court, this is reported in 2025 SCC online, SC page 343. Techno case versus Chhattisgarh Textbook Corporation. Kindly comes to page paragraph 27.
Para 27.
Page 343. These 14 blue teams advertisement private limited and Kolkata Municipal Corporation 2024 while watching the set aside the blacklisting order as affirmed by the Honorable High Court in almost identical fact observed as under. I am on point 2. The penalty of blacklisting may only be imposed when it is necessary to safeguard the public interest from irresponsible or dishonest contractor. I say, the petitioner is the irresponsible, the contractor did not, the perform is due to within the time stipulated in the agreement. That upon the last occasion I have handed over the one memorandum the issued by the Chief Secretary, Additional Chief Secretary, Government of West Bengal regarding this issue. The tender matter. This document clause number 41. Clause 41. First, my lord, you find this is the tender and contract for work, general rules and directives and guidance of bidder, applicability. Now, clause 41. Procedure for suspension and debarment of supplier and contractor and consultant. The serial number 12. Failure of the contractor due solely to his fault or negligence to mobilize and start work or performance within the specified period as mentioned in the letter of acceptance, letter of acceptance and work order or work order notice to show on. There is these guidelines says now considering this two issues due to his unprofessional approach, the public interest has been hampered. So he has been so-called notice issued by both the ADM and LR in the Purulia district and the Purbo Bardhaman district. He replied, his reply was unsatisfactory. and his was terminated, and he has been debarred from work for 3 years. Now 3 years, that is 2023. That is almost kunta.
Yes.
Now this so my respectful submission, due to this to save the public interest, this is not the only time, and this is the third wave, this is the necessary in the tender note specifically mentioned the clause 8 of the agreement also. So regarding the blacklisting, so these are the 2 points.
So you say that in order to save
the public, that is the public
in the interest of public, but you can blacklist in the interest of public without complying with the opportunity to.
Opportunity was given, although in the so cause notice that was not specifically mentioned. Why you
that
should
is
not
the
be
point. That is the point on which he has not been heard. On the point of blacklisting, question. One of the questions should have been whether he should be blacklisted or not. That was not the question put to him. That is his point. That if you have condemned me on a point on which I was not given an opportunity to rebut, whether that point can be considered and then that can be held against me. That is the point.
Now, to save that, that although
very well, I
specifically
shall consider it.
And
yes, Mr. Banerjee. Paragraph 3, yes. You have given 2014, 2012, and 2020. You have given 2014-9. You have given 2012 Supreme Court. You have given AIR 2020 Supreme Court. Paragraph 21, 25, 26. No, AIR 20 Supreme Court, you cited paragraph 12. AIR 20 Supreme Court ends at paragraph 16. You had given this Wet India Pharmaceuticals Limited versus State of Uttar Pradesh. Yes, this UMC you had given, but it had gone back to you. So this is not in the file. Paragraph 20 of this one. Paragraph 21, 25, 26. Very well. I will not say anything on this. Where is that averment in the writ petition? It's there.
That is in the agreement, that clause is there.
No, where is the averment in the writ petition that somebody else has already been engaged? During pendency of the writ petition, balance work or the entire work? So your challenge here is only limited to show cause. So that I am recording the.
No, that is from the materials of record. It appears they himself, they stated that due to the lack of manpower, they are not able to.
Mr. Banerjee, your prayer is only for considering the your representation and setting aside the blacklisting order. That is the prayer in the writ petition. There is no other prayer. Yes, this is the scope of the writ petition. Scope of the writ petition is only show cause. But that is not required to be gone into, because the scope of the writ petition is only this much, that you were blacklisted without hearing. I will set aside that. Whatever remedy you have, I am not negating, because if that was a prayer made, only then res judicata would have come. That was not a prayer made. So blacklisting order, only blacklist, setting aside, yes, setting aside blacklisting order. The blacklisting order. So only blacklisting order is under challenge before this court. Whatever I pass will be limited to blacklisting only. Mr. Banerjee, since you have not made any prayer as regards the balance portion of your challenge, that is not the subject matter of adjudication here. So therefore, there is no question of leaving it open or speaking anything on that. Only if prayer is made. Constructive res judicata will apply only if prayer is made. So ought to have made, that is order to rule 2 for proof, not here in brief. Yes, but then but if it has happened during pendency of the writ petition, it is open to you always. It's always open to you. And where is that averment? I need to have that averment. No, these are all what was not done, but yes, where is that? Because your prayer does not say that.
In the Supplementary paragraph 6 also, he's one of the stating
Yes,
about
in
the
the supplementary affidavit also you have not said that. It is not there, miss, in the supplementary also, it is about blacklisting only. That is there, but there is no prayer to that effect. You have to have made a prayer and then you could have sought leave. No, blacklisting your remedy is because you will be out of business for the next 3 years. That is the remedy which you will that you will get here. But you have not prayed for that. You have not prayed for here. How can I incorporate that? You file a fresh supplementary then. You file a supplementary.
Then
so that
my
you incorporate-
respectful submission in that event, for amendment of prayer, amendment application required by way of.
Now he's taking an objection. You file an application for amendment.
By supplementary affidavit, the prayer, how the prayer can be.
No, I will set aside the order of blacklisting only that part. Where is impugned order? I don't find. Where is impugned order written? No, no.
In the prayer, there is no
prayer. Your prayer is specific to blacklisting. You kindly come to page 13, 1-3. Yes. Setting aside blacklisting order. That is the only prayer. Where? It's not there.
The prayer be statutory, three rule nice side. And in that issue, my specific, the prayer, the arbitration clause is there.
That remedy I will keep open. I will say that in terms of the supplementary, if I interfere, I will interfere only to the extent of blacklisting so that they can be given notice. Termination part I will not touch. I will say you will avail your remedy in terms of the agreement. In terms of the agreement.
And regarding the blacklisting, some irregularities there that was not mentioned, that is not the closed our action.
No, that will not. I'll give you liberty to issue show cause, give him a hearing and then blacklist. It's not that I'm absolutely closing it, only on the point of natural justice. If I interfere. Five.
Sir, vacation. Second one.
Uh, Learned advocate appearing for the petitioner. Please take the mic. Mic. The mic is not working. Yes.
Yeah, earlier your lordship instructed the respondent authority to submit the report
Yes.
on 7th November.
After the transfer of the bank account, the person is brought to our office. That's under the petitioner has filed a petition. Contention that their account, because they have took a
Their
loan.
account?
Their account, they have took a loan in the year 1991. And the bank was crediting savings account on the basis of SOP. So he filed a requisition before the Honorable Court, taking direction upon the bank not to deduct the EMI from his savings account. That requisition was second, his certificate has been seized by the CBS because he found guilty in one for illegal investment of the account. Third, he is still in due with respect of the loan account, which he took loan from the bank. I have announced the last one is the statement of account, 13 lakh amount, still due announcement. So that is why the bank has put on hold. But all these facts have been separated in the report. Yes, madam. Yes, sir. You take instructions on this.
No, my lord.
Instructions on the report.
Okay, my lord.
Well, I understood only. Very good.
Bye.
Mr. Singh, learned advocate appearing for the respondent bank. Yes.
Lord, I beg to appear for the petitioner. Lord, am I audible to your lordship, Lord?
Yes, you are.
Lord, this is a matter not concerning. We have challenged two notifications. Lord,
Chakravarti is appearing for the enforcement directorate. Due to some personal reason, he is out of the hearing.
if my management speaks in front of the microphone, I can hear her. I could not
Mr.
hear.
Chakravarti has some personal difficulty. He has not been able to come to court today.
Arijit Chakraborty.
Yes.
As personal difficulty, I cannot oppose, my lord. But if
Let
the
him stand
difficulty,
over till after the vacation.
no,
we
the
will-
difficulty, my lord, kindly record only one line. Then, my lord, I beseech you, lordship. Why? Because since they are seeking time, third is the date for framing of charges. We have challenged the jurisdiction. At least, my lord,
Anyway,
kindly record.
even if charges are framed, if we have challenged
Lord, kindly
jurisdiction,
record.
the challenge, Mr. Chakravarti, if the challenge to jurisdiction is sustained, everything will go.
Not only one thing. If
Let
my
it
lord,
continue. I will not stay.
no, I am not saying that. Kindly record that the ED has prayed for time. Only that. Kindly record that only.
Yes, that will record.
That can be recorded, my lord.
Yes.
That we are here, ED has prayed for time, so my lord is keeping it after vacation.
Again, from
His personal difficulty, I am the last person to oppose.
last time also I appeared on behalf of the state because of the nation. But names are not coming.
Please
Names are,
give the names. All the
I
names
have-
which are there are coming. I personally check it. No. I personally check it, ma'am. All the names which are there in the slip, they appear. Because I
dated 21st, this thing happened, Lordship. That's why I'm just mentioning.
names might not have been given to the officer. Yes. An adjournment is prayed for on behalf of the respondent,
Enforcement Directorate.
the respondent enforcement directorate. Full stop. Accordingly, list this matter on January 16, 2026.
Great.
Not on that day, I believe they will be appearing, my lord, because I am not being able to move the matter. I'm not at the threshold.
Last time adjournment was prayed on your behalf.
Hey, sorry, my lord. I withdraw the I withdraw that. I'm grateful to Lord.
And for Union of India.
None appears for the petitioner. No. Six 630. Who is appearing? You are appearing. All হয়েছে তো matter জিজ্ঞেস করুন উনি কি আছেন? You are there in 630. Next matter you are there. 629 and 630. Respond to the code then. Same order করুন. Not today.
For the respondent was court decided by Mrs. Situ Singh.
632, my lord, this is my petition.
We appearing another court of law.
My petition, my lord, may I indicate this is that matter, my lord, where the water connection was not given. Now, my lord, on the last occasion, I just indicate to your lordship, I'm not. It has come back to me. It's recorded in the order. Somebody else has paid the charges. Now, what had happened, my lord, a report was filed by my learned friend saying that, my lord, the sister company of the petitioner, my lord, had paid the money and water connection was given to them. My lord, I've checked the writ petition. In fact, my lord, no money payment has been paid because the quotation has not been issued for the water connection. My lord, I was humbly beseeching, my lord, if your lordship can give a direction.
Engage another photographer for password and.
Pass it over. Pass it over. No. No, or my lord, if lordship can kindly give a direction because water is an essential supply. I have to hear them. I don't know what they have to say. My lord.
Lordship, I am appearing on behalf of petitioner. Learned Counsel, Mr. Rishabh Kandani is appearing in another court. I am appearing for short passover.
Passover.
Your Lordship, I'm for the petitioner, led by Mrs. Kankana Bhattacharya. I'm paying for short passover.
Everybody is paying for. There was no order for amendment. It was for them to take appropriate steps.
My senior.
I remember there. I cannot direct them to amend. It is for them to amend. There is no order for amendment.
My senior is just on his way. I'm paying this short passover. Your Lordship.
Passover.
Yes, Your
Passover. Next. Passover গুলো আলাদা রাখবেন
I am for petitioner. My signature on his leg code number 14. I am paying a short passover.
Passover. Next.
I beg to appear on behalf of the petitioner, my lord. The petitioner is the unfortunate mother, and my lord, the Senior Citizen Protection Act, my lord, is also applicable over the case. My lord, at a point of time, they have deposited certain amount in a bank. My lord, the bank, my lord, the central bank, Kolkata main office, my lord, Netaji Subhash Road, and my lord, the fixed deposit which is lying, my lord, the original lying with the son. And my lord have been tortured. Father and mother both have been tortured. They had to leave the house and residing at the daughter's house. Lordship will find from the page 19, my first information report before the Sakrail police station, my lord, which is also still pending, my lord, pending adjudication before the appropriate court.
Page 19.
Page 19, this is the first information report. 20 may kindly be looked into. This is the complaint addressed to, my lord, the OC of Sakrail police station. My lord, may I be permitted to read. আমি শ্রী দীপ্তি ঘোষ, স্বামী ধনঞ্জয় ঘোষ, সাকরাইল থানার অধীনে মধ্য জোড়াহাটের বাসিন্দা। মেটিয়াবুরুজে আমার বাবার বাড়ি। বাবার মৃত্যুর পর আমার পৈতৃক সম্পত্তি বিক্রয় করার ফলে আমার অংশের কিছু টাকা পয়সা গত 2019 সালে পাই। সেই টাকা পাওয়ার পর থেকে আমার ছেলে সঞ্জয় ঘোষ, মাই লর্ড, ওই সমস্ত টাকা পয়সা তার নামে হস্তান্তর করার জন্য আমার উপর শারীরিক এবং মানসিক চাপ সৃষ্টি করতে থাকায় আমি তার নাম বরাবর প্রায় 12,50,000 টাকা প্রদান করতে বাধ্য হই। কিন্তু তাতেও তার দাবি মেটে না। সে আমার উপর শারীরিক এবং মানসিক নির্যাতন চালাতেই থাকে। অবশেষে বাধ্য হয়ে আমি বাড়ি ছেড়ে মহেশতলায় তারিখে আমার মেয়ের বাড়িতে আশ্রয় নিই। কিন্তু তা সত্ত্বেও মানে টার্ন টু নেক্সট পেজ, আরো টাকা পয়সার জন্য নিত্য মানসিক চাপ সৃষ্টি করিয়া চলিতেছে। যেহেতু উপরিউল্লিখিত বাড়ি থেকে আমার চলে আসার সময় আলমারিতে থাকা টাকা পয়সা আমার ছেলে জোর করে আটকে রেখেছে। যেহেতু আমার সমস্ত জিনিসপত্রাদি আমার স্বামীর গৃহে রয়েছে, গত 2/1/2023 তারিখে খবর পাই যে আমার ছেলে সঞ্জয় ঘোষ আমার আলমারিতে রাখা জিনিসপত্রাদি, সোনার গয়না বের করে নিয়েছে। সেই সমস্ত কিছু জিনিসপত্রাদি আলমারিতে ছিল তা বিক্রি করে দেওয়ার চেষ্টা করেছে এবং প্রয়োজনীয় কাগজপত্রাদিতেও বার করে নিয়েছে। মানে the grievance is, my lord, my prayer is, my lord, read in the nature of mandamus, immediate step to issue duplicate certificate, our 4 fixed deposit certificate. My lord, the bank, my lord, the original certificate are lying in my that particular armory. I am not in a position to enter into that house. And that, my lord, the duplicate certificate may kindly be issued, directed to be issued, my lord, so as to enable me to encash this particular amount. And at the same time, my lord, second, my lord, allow me, my lord, to withdraw that amount that is in joint account with my son. My lord, I had to do all these things. Now, well, the situation is miserable.
If it is with in joint account, then
Lord.
in that case, unless the account is operable in either or survivor mode, you alone cannot be allowed.
No,
to
my lord, the
execute
only
it.
difficulty since it is coming within the four corner of my lord the senior citizen, as a result of which, my lord, even my lord, the deed is executed in favor of someone, my lord, deed can be cancelled. Well, that being the situation, legal proposition of the law, my lord, nowadays.
Show me that law.
My lord,
And show, my lord. The bank will go according to the mandate.
we have implemented bank also, my lord, they should come forward. Lordship, kindly see.
No, my lord, I am for the restaurant number 4. This one.
787, my lord,
Unfortunate, very unfortunate, son.
2025,
There is no position. We are at
2025, 2 STC 787. একটা copy দিন। My lord, bold portion may kindly be looked into, my lord. 2025, 2 STC 787.
So this is gift deed. How is this applicable?
No,
Gift
my
of
lord.
somebody else's property gifted to somebody else.
True.
This is joint account
True.
opened by two
True.
people.
My
in the
lord,
name of
kindly
two people.
consider.
It does not apply.
My lord, allow me to make this submission. My lord, allow me to make this submission. Supposing, my lord, I have executed a deed in favor of someone. Gift. He has taken the, my lord, the property. Whether I am able to cancel it in any manner whatsoever, unless a fraud,
That can be cancelled.
unless there is fraud and misrepresentation.
That logic cannot be imported to joint account.
My lord, because of, my lord, keeping in the mind of the betterment and
Because
welfare.
Gift is voluntary relinquishment of right
True.
over a property in respect of somebody else.
Once relinquished, always relinquished, cannot be taken back, my lord.
Whenever there is a joint account,
Lordship.
it gives joint ownership from the very inception.
Lordship.
There is no question of
So
relinquishment.
at least allow me to enter into that particular premises and, my lord, to, my lord, inquire.
Is a different
So, my
story,
lord,
but here the first prayer which you make, allowing second prayer which you make of allowing you to withdraw sums and all, I don't think I have doubts whether that can be subject to
so, my lord, that is
correction by you.
that to be decided
Let
by
the
the
bank come.
in presence of bank, my lord.
Let the bank come.
Lordship.
Now, 4 accounts are not there in the second matter. You said yes. Yes, 4 fixed deposits.
4.
4. Same. Next. In PM, I will not be able to take it up. Adjournment is prayed for on behalf of the petitioner. full stop, list this matter.
My lord, I am appearing for Reserve Bank of India in the matter, respondent numbers 1 and 2.
Yes.
This is the matter where my learned friend had disclosed by way of a supplementary affidavit the fact that the second complaint which was lodged by them to the banking ombudsman was disposed of. So that he has indicated, which I had indicated at the first sitting. And then your lordship will find that the reliefs which have been sought for is primarily against the Axis Bank, coupled with the fact that the investigation is going on. So the investigating authority has to come before your lordship and indicate what is the stage of the proceeding. This banking
Investigating
ombudsman
authorities
has,
are not parties.
they are the parties, but if your
You are
lordship will
appearing for whom?
find,
I'm appearing for the bank, my lord.
Which bank?
Axis Bank. Yes.
Axis.
And who is appearing for the state authorities? 7 and 8.
last occasion also
The
they did not
petitioner,
appear, lordship had passed
My
an
lord.
order.
My lord.
the petitioner shall serve a notice on the respondent numbers 7 and 8, as also on the office of the learned government pleader, intimating that the matter shall be taken up next on January 9, 2026, full stop. The Reserve Bank of India and Axis Bank are represented, full stop.
Grateful to lordship.
Nine.
16 করে দিন।
Lordship items.
Let it be 9, you because she has left now. 9th. Didi, 9th hi থাকবে। 9th. Come back up.
Okay.
গুলো call করবো।
Grateful,
After this is over, after this one is over, I'll call passover matters. No, no, because you were there.
Lordship, I am for the respondent number 11 and 12, the private respondents.
The petitioner was there on the last occasion.
Direction was, right.
None appears for the petitioner. Full
Lordship,
stop.
I just want to mention one thing, Lordship.
ওপর থেকে আছে। হ্যাঁ 12 নম্বর ছিল না একটা। Page 43.
Since there was regarding the appellate of the district
DM.
I challenge the order of the SDM for the earlier. So that was dismissed. Since the appellate of the so I filed the appeal before the district magistrate for around one and a half months. There was no notice regarding the hearing. Then can we take after filing of the district magistrate has sent a notice for
Yes.
for the reached on 8th of December. On that particular day, the matter was taken up. But till now, no order has been passed in that.
8th of December, we are only 10 days.
But in the meantime, the urgency is this that Telangana municipality has issued a demolition notice on 25th November. I filed the petition on 24th of November. It will not kindly take demolition.
That was pursuant to the order of the 11th of September, section 4 order.
Now, the municipality is disturbing the petitioner. I am only on this, let there be a stay, till the.
You go and say this before the DM. How will I stay here? It is already before you are before the appellate authority.
He has approached several authorities. First, page 30.
Unless the
Kindly see page 30.
I cannot.
It's a wasted land.
Go
He has
to DM and say I'll give you liberty to approach the DM with this also that they are seeking to execute the order. DM will pass appropriate orders. If necessary, he will stay or he will not stay, whatever he is.
He has been hovering around with many authorities. First, he approached
Page
page 30. He first he approached the PLR for record correction. That was kept pending. He didn't pursue that. Then again, this came up.
Very well. Affidavit of service filed today be kept with the records. Full stop. Me too.
I am here for 6:30.
Yes.
The last occasion, my report, not saying that sister company of the reputation has been taken. In fact, my lord, I've checked the reputation. Our prayer is, my lord, that despite representation, occasion is not being issued, so we are unable to take. Water being an essential commodity, my lord, we are in the leasehold premises, valid subsisting lease. Where you know, kindly directs my lord, provide a quotation. We are ready.
No, but your prayer was that you have made you had made payment. That
Yes,
was
my
the
lord.
submission.
Clear
that you made.
submission before your lordship,
It was a
they have
submission,
paid.
but the prayer I have checked in the body of the requisition is not being pleaded.
Because that is what is recorded in the order that you have made payment.
Yes.
My lord, I had, my lord, under a mistaken belief, my lord, I have submitted that. I have checked the reputation, my lord, and the prayer. That is not the case made out of the reputation. If your lordship kindly consider the prayers once at page 13. So the grievances, my lord, that despite representations, my lord, the quotation
Page
is not
13 is why water connection should not be granted.
connection should not be granted. Lord,
So if
we have-
representation consideration was the prayer, that should have been made at the first
My lord,
place only.
lordship, it was a mistake on my part. Your lordship, my lord, kindly, I will have to decision your lordship. Quotation can be issued, my lord, we are ready.
No, issuing quotation will not be passed by this court. They have to consider the representation if at all it is issuable, whether it can be issued in your favor or not. Because I cannot go and ask for quotation in somebody else's premises if somebody else is already enjoying there. That will have
Admittedly, I am in the premise.
no, that is not admitted. Their case is different. There is a different entity. So that order will not be passed. I can at the most say that they can consider the representation and answer. They'll give you a reason if they want to give you, yeah, they are free. If they don't want to give you, they'll give a reason why they don't want to give you. That's it. There'll be no order directing them to give water connection. To consider the representation, pass appropriate orders.
My lord, kindly, my lord, mention this page, my lord. My lord, kindly mention this page, my lord, because my lord, other
Yes,
companies' prayer is.
No, I'll mention the page.
My lord,
Page
Pages 36, 37, and 43.
thirty-six.
36, 37, and 43, madam.
लिखो Yes.
My lord, at the outset, please accept my apology, my lord. I was occupied. My lord, if your lordship, my lord, by your lordship's last order, if your lordship takes, my lord, of 7th November, your lordship has recorded my submission and the matrix of the matter has now become very limited, my lord. Briefly, my lord, the facts. The petitioner applied for a sand mining lease, tender process, obtained the lease, paid the total amount of the lease rental as per the clauses of the tender, received a registered document in its favor. Thereafter, the possession was to be handed over to the petitioner for the petitioner to start its work of mining in the demarcated land. My lord, the possession wasn't being handed over. There were several letters written. Admitted fact, my lord, at page 91 of the writ petition, my lord, when the possession was finally given to me. There is a writ of possession by the government when the possession was handed over. It's our case that 21 to 22 months after the execution of the registered lease, the possession was handed over to me to begin my work. The lease period was initially for 5 years. Now, my lord, when we filed the writ petition, our prayer in the writ petition was limited that 21 months to be excluded. And in the portal, they maintain a portal, my lord, where it shows that when the lease started, when the lease would expire. To change the expiry date by a further period of 21, 22 months, my lord, to allow us to utilize that period which was not being utilized because possession was admittedly not handed over to us. My lord, it could be either in two ways. One, my lord, that my starting date changes, or my lord, the end date of my lease tenure changes. Initially, my lord, I had tried to make a submission, my lord, that the starting date might change, to which, my lord, my learned senior friend had come forward, said that that may not be permissible as per the Mines and Minerals Act and specific provisions. Your lordship had considered and had asked me to come back, my lord. Now, my lord, the second aspect is, my lord, if my starting date cannot perhaps change, my end date of the period, there is no restriction in the law, my lord, which says that the end date cannot change. And, my lord, I am armed with one judgment, my lord, of our coordinate bench, my lord, of our High Court, my lord, I had placed before your lordship, my lord, on the last occasion, and your lordship had marked that judgment, my lord. If your lordship takes that judgment, shortest judgment, my lord, this is the unreported judgment in WPA 1484 of 2021, Chopin Sarkar, my lord. Your lordship has it. My lord, similar point was under contention, my lord. Extension for COVID period and not handing over possession. If your lordship takes the second page, the paragraph at the top, which
From
says
date of delivery of possession.
Yes, my lord. Here, my lord, before, my lord, I just want to point out one fact in this matter, my lord. If your lordship takes the second paragraph at the top, the petitioner was given possession of the leasehold property on or after 26th April 2017. So there was a delay in handing over possession. My lord, third paragraph in the same page, the petitioner has placed reliance upon an order dated such and such passed by a coordinate bench and an order of honorable division bench of this court passed on October 7, 2013 in FMA such and such, wherein it was observed that the period of lease ought to be considered from the date of delivery of possession. My lord, after considering all the submissions, my lord, and the facts, eventually the court held, my lord, in the next page, considered Rule 21, my lord, next page middle, considers Rule 21 of the West Bengal Mines and Minerals Concession Rules, and thereafter, my lord, as laid down by the earlier judgments of this court, the term of lease ought to commence from the date when delivery of possession of the leasehold land in question is handed over to the petitioner. As in the case in hand, the petitioner acquired possession of the land only on or after 26th April 2017. The period of lease shall be counted from the said date and not from the date of execution of the same. In the result, the period of lease is extended. My lord, this, my lord, it's my duty to point out there was an appeal carried out from this order. There was one more copy, yes, sorry. My lord, there was an appeal. I'll just hand over another copy to my learned friend.
I do have. It's a part of the bunch of documents I've handed over to you and the honorable court also.
My lord, if your lordship takes the order in appeal, then my lord.
It's a part of my document will hand it over to your lordship.
30th of January. This is the order passed.
Yes.
30th January 2023.
Yes.
My lord, I would not want to interpret this order. There was an appeal carried out by the state challenging a portion of the order.
Yes.
My lord, but the if your lordship takes the appeal, my lord, the state had challenged this order to the limited extent of the factual matrix of the matter. One pertinent point was that the 2 years which the extension was sought, that had already passed, so the appeal had become infructuous, but the state went up in appeal because, my lord, to challenge that the petitioner before this court continued to be in possession. And if this order was to be read in such manner, to extend the possession of a person who continues to be in possession, and there is just a procedural lease agreement which is renewed subsequently, but the possession of the petitioner was not dislodged. That part was clarified by the appeal court, my lord, if your lordship takes.
Yes, if it is in continuous possession, then in that case, that will not apply. Your case is not.
No, my lord. It was the first lease. First lease, I was to be handed over possession. It's not their case that I was in possession. My lord, so two things, my lord, from this order. One, my lord, a factual matrix had sought to be clarified by the state. My lord, the state did not prefer an appeal from the finding on law, if I may say, my lord, that when the date of possession would start or when date of lease would start, whether from the date of possession or whether from any other date. My lord, when that part, whether it was questioned in the appeal, my lord, I will not be able to be in a position to say, my lord, but from the appeal court's direction, that part was not touched in this appeal. My lord, so it is my respectful submission, my lord, that the appeal court confirmed that part of the order of date of possession. My lord, that is
My lord, the appeal of discord, my lord, is very simple. That he has been granted, my lord, the lease for 5 years. My lord, that 5 years, my lord, the registered deed of lease is a part of this writ petition, which is appear from page 20 of the writ petition. Date of execution registration is 9th July 2021. 5 years come to 2026. The Melanet friend comes up with a representation, my lord. That is at page, my lord, 95 of the writ petition, where he says that since I have been handed over the possession of the block, sand block, on 23rd May 2023, therefore my 5 years lease period has to be counted
from the date of
on and from 23rd May 2023. Hence, it shall come to end on 22nd May 2028 and not on 2nd August 2026, which is appearing in the portal. My lord, my first full submission is point of law, which my learned friend has been urging. Law is very clear on this. My lord, if I may respectfully invite your lordship, on the last occasion also, my lord.
But Mr. Ghalib, if the coordinate bench has held it and that has not been disturbed, and I noticed that the coordinate bench has also relied on a division bench judgment.
My lord, I am coming to that. Very soon I'll be coming to that point.
The letter of law has been interpreted by the court in a certain way.
Letter of law, my lord, has not been dealt with, if I may respectfully, my lord.
No, but
letter of law, my lord. It is a different factual background. It was altogether different factual background.
No. The factual background would be different for the purpose of reckoning of the lease in a case where the lease is continuous. His case is not of a continuous lease because
it was an issue of renewal. Since the papers were, my lord, not ready with regard to the issue of renewal, that's why the issue was, my lord, dealt with in that particular manner. So, my lord, the order is to the judgment or order is to dealt with against the factual matrix of the case concerned.
Correct.
And not the logical conclusion to deduce
that. Also of renewal.
Lordship, no, here the judgment which my learned friend is relying
his case is not of renewal. That is the point.
So, my lord, that judgment is not applicable to the factual matter of the present case.
No, Mr. Ghalib, the
my lord, before going to that, may I refer to the law, my lord, first. My lord, concession rules 2016 is very clear. My lord, may I refer to one rule? That is rule, my lord. Rule 5 of the concession rules, my lord, 2016.
Rule 5.
Rule 5 of West Bengal Minor Minerals Concession Rules 2016. These rules are friend, my lord, in exercise.
You have a copy of the rule?
Sorry, I did not sure. My lord, this subordinate legislation comes, my lord, in exercise the
Rule
power
5.
under section 15 of minor mines and minerals development. These rules have been framed. The concession was 2016. Rule 5, my lord, kindly seize, my lord, sub rule 2. The date of commencement of the period for which a mining lease is granted shall be the date on which a duly executed lease deed is registered as per the conditions laid down by these rules. So, my lord, these date of execution will be the date of registration. Commencement will be date of registration as per the conditions laid down by these rules. That is one.
Just a minute. ওনাকে ডাকুন তো।
So, my lord, date of commencement will be the date of registration of the lease deed. Now, my lord, next rule, my lord, if I may respectfully invite your lordship, my lord, to the auction rules, my lord, of my lord 2016. My lord, West Bengal minor minerals auction rules, my lord, 2016. These are also the rules, my lord, which are framed, my lord, in accordance with section 15 of the Mines and Minerals Development Act 1957. What does it say, my lord? Kindly seize. It's rule 10, my lord. Auction rules 2016, rule 10, sub rule 6. The date on which a duly executed mining lease deed is registered shall be the date of commencement of the mining lease. Now, my lord, on the basis of auction, after coming into force of this 2016 rules, all the sand blocks are only, my lord, distributed, my lord, on the basis of e-auction. After that comes the, my lord, the agreement. So, after these two rules, may I respectfully invite your lordship, my lord, to, my lord, the privity of contract between the petitioner, lordship, rule 10, sub rule 5 of the auction rules.
Auction.
It is part of the same book. Lordship may kindly come to, my lord, page, my lord, 107, if it is common law house.
It's a different edition.
West Bengal minor minerals
Yes, I have got it.
auction rules 2016. These rules, my lord, are also framed, my lord, in exercise of the power under section 15 of the.
Just a moment. Cannot. Yes. Auction rules. Yes.
My lord, in these auction rules, my lord, may I respectfully invite your lordship, my lord, to, my lord, page, my lord, this rule 10,
6.
sub rule 6.
Yes.
The date on which a duly executed mining lease deed is registered shall be the date of commencement of the mining lease. So, here also, my lord, same thing is being reiterated as on concessions 2016. Now, my lord, after coming into force of this 2016 rules, my lord, all the sand blocks, my lord, are being, my lord, distributed on the basis of e-auction. Thereafter comes the agreement. Now, the agreement, my lord, kindly seize the agreement which was entered into by the collector, by and between the governor, represented by the collector, and the petitioner. My lord, may I respectfully invite your lordship to the agreement. Page 59, my lord, kindly comes to straight away to the relevant clause. The agreement starts from page 20. And may I respectfully invite your lordship, my lord, to page 59.
Page 59.
It is part of the agreement, my lord, that is the agreement by and between the petitioner and, my lord, the governor. Page 59 of the writ petition, my lord, may I respectfully invite your lordship to clause 29. Kindly seize, my lord. The lazy and lazy shall abide by all existing rules and laws and rules and regulations enforced by the government of India or the state government, district authority, and all such other laws, rules, and regulations as may be enforced from time to time in respect of working of mines and minerals and other matters affecting the safety, healthy, and so on. So, my lord, kindly, my lord, juxtapose this clause 29 of the privity of contract, this agreement. Kindly, my lord, see also, my lord, the concession rules which I have shown to your lordship, that rule 5, sub rule 2, date of commencement of the period for which a mining lease is granted shall be the date on which a duly executed lease deed is registered as per the conditions laid down by these rules. So all these rules, my lord, have also been taken care of in the contract or the agreement which has been entered into by the parties, by and between the parties. So, my lord, he is, my lord, governed by all these rules, my lord, which are in vogue as on date while the agreement was entered into by and between the parties. Now, my lord, my learned friend has referred to the single bench judgment followed by the division bench judgment, which the appeal was preferred by the state. Lordship, my lord, that particular division bench order, which is also in the part and parcel of the bunch of documents,
Yes.
which I've handed over to your lordship on the last occasion, my lord, that is dated 27th February 2025 is the forwarding letter by the ADM. And may I respectfully invite your lordship, my lord, to, my lord, page, my lord, 9 of the, my lord, bunch of document that I had handed over on the last occasion.
Yes, yes.
Kindly seize, my lord, my learned friend, my lord, has referred to a single bench judgment, my lord, of WPA 14848 of 2029. This particular order was appealed against by the state. And what does the Honorable Appeal Court says, my lord? Kindly seize. There was a can to so and so. My lord, may I read out the first page of the order? This appeal is directed against the judgment and order dated December 17, 2021, whereby the respondent's writ petition being WPA 14848 was disposed of by the Honest Singer by giving certain directions. It appears that a long-term mining lease was granted by the state in favor of the respondent on November 10, 2008. The lease was subsequently renewed by an agreement dated 8 August 2016 for a further period of 5 years. Before the learned single judge, the respondent petitioner contended that he was given possession of the leasehold property on or after April 26, 2017. Accordingly, the authorities should extend the period of lease upon consideration of said period commencing from the date of delivery of possession of the land to the petitioner. A further prayer of the petitioner was that his representation dated 12th August 2021 made to the authority should be considered and disposed of. The learned judge, my lord, the entire, my lord, text of the order, my lord, has been quoted. I shall not travel your lordship with the same. Thereafter, my lord, may I respectfully invite your lordship to internal page 3, my lord, page 11 of my report. Being aggrieved, the state has come up in appeal. This appeal has really become infructuous. The portion of the impugned order whereby the learned judge directed that period of lease would be considered to be valid till April 25, 2022 has worked itself out. That date has gone by. As regards the representation of the writ petitioner, we are told that the same has been considered and disposed of. Here, the representation is pending. As on date, it has not yet been disposed of. May I pause for a moment? The factual matrix. The representation has not yet been considered. Secondly, my lord, Mr. Banerjee Learned's standing counsel representing the state is agreed with the fact the learned judge directed the lease should be considered to be valid till April 25, 2022. He submitted that the writ petitioner has been in possession of the land in question since 2008. That is the period from when the original lease period started. The renewal of the lease in 2016 was only a matter of paperwork. The writ petitioner was always and continuously in possession of the land. Hence, the direction of the learned judge extending the validity of the lease was uncalled for and will set bad precedent. Mr. Banerjee further submitted the delay in completion of paperwork as regards renewal of the lease was due to the delay on the part of the petitioner to furnish environmental clearance certificate. This is disputed by the learned advocate appearing for the petitioner. We think Mr. Banerjee is right. There is nothing on record to show, and the learned advocate for the petitioner has also not been able to demonstrate that at any point of time, physical possession of the land in question was returned back to the state. If that be so, that is, if the writ petitioner was always in possession of the land in question, then just because there might have been a delay in completion of paperwork, there was no warrant for extending the lease period. As a matter of principle, we thus clarify that if the lessee in any manner was in continuous possession of the land in question, mere delay in completion of paperwork pertaining to renewal of the lease would not be a ground for extending the validity of the lease period. My first full submission is that this was against the background of a renewal of lease. As on date, after coming into force of 2016 concession rules followed by auction rules and storage rules, there is no renewal, Milord, provision of any of the lessees who have been granted lease on the basis of e-auction pursuant to the coming into force of 2016 rules. So that was against the background of the old existing rules. Milord, sand mining policy, may respectfully hand over to your lordship. It is very much categorical and clear that there is no renewal provision as on date, Milord. Kindly cease, Milord. The sand mining policy, Milord, of 2021. That copy down. It is available on the portal. Milord, straight away, may I respectfully invite your lordship. This is the policy of the government, Milord. The sanctity and validity was also, Milord, upheld by this honorable court of this particular policy. And will kindly cease, Milord, if I may respectfully invite your lordship, Milord, to Milord, internal page 232 of this particular policy paper, Milord.
Yes.
Kindly cease, Milord, clause that one. I'm handing over. Kindly see only make clause plus Roman 3. Transfer of existing mining leases. In existing leases, the lease shall not be renewed and shall automatically be resumed and vested with the state government upon expiry of such leases. The state government shall then lease the sand minings to West Bengal Miner Development and Trading Corporation Limited or any agency recommended by it. So, Milord, upon expiry of this lease, so this particular lease is governed by this particular sand policy. The division bench judgment preceded by the Milord, the single bench judgment was against the backdrop of the rule wherein there was a renewal, Milord, provision, and in almost all the Milord lease agreements, Milord, that were executed prior to that period, they invariably, Milord, contain the renewal clauses. So here, as on date, there is no such. So against the background of renewal provision, that particular judgments were, Milord, delivered. And moreover, Milord, paperwork. So here, paperwork, Milord, cannot be taken into consideration because paperwork was with regard to renewal of lease of paperwork, not with regard to the paperwork of the original lease granted in the year 2008.
What was the reason for delay in handing over possession here?
Here, Milord, I have been, Milord, given an instruction on this issue. Milord, may I respectfully hand over a copy? Kindly give a copy to my learned friend, to the petitioner also. Milord, kindly seize. Here, this is the instruction dated 18th April 2025 by the ADM and DLLRO Pushing Bardhaman. Kindly seize. Concerned BLRO was asked to deliver the possession of the sand block on 15 December 2021. VDA memo number 156 dated so wherein petitioner was also informed to take over the possession. Kindly seize, Milord, the communication dated 15 December 2021. That is at page 2 of the Milord, of the bunch of documents. So he was requested, BLRO informed. Kindly seize, Milord, the copy was forwarded to Triumph Sales and Services also. 15 December 2021 is the communication from ADM to the BLLRO with a copy to TRAM. This copy was also handed over through mail to the petitioner also. Kindly see page 3. I've handed over a copy of this bunch of documents. On 15 December 2021, he was also informed, the petitioner I mean, that please you take over the hand over the position of this. Page 3 is the mail. Next comes the action of 9th March 2023, where again the ADM is requesting the BLLRO what happened. Please hand it over to him with a copy. And this copy was also given to the petitioner. Kindly see page 5. That is the email version. So these two communications dated, one is 15 December 2021, second dated 9th March 2021. The first reminder, 9th March is, were not acted upon. And third was this writ of possession, that is 23rd May 2023. So two requests were there from the authorities to the petitioner. Please would hand over the possession, take over the possession also. So these were there. So this is the factual aspect. And the legal aspect is, as on date, these two rules are staring in our face. 2016 concession rules, rule 5 sub rule 2. And auction rules 2016, rule 10 sub rule 6. This judgment is, third respectful submission is third. These judgments are against the back. And
now it's once my learned senior friend come.
And my learned friend kindly sees, has also referred to one single bench judgment of this honorable court is WPA 11031 of 2020.
I have not formally cited that.
Oh, you have not cited it. Already I am not pressing it. I would like to just disturb your lordship, with one judgment, of the Honorable Supreme Court, because after this Deepak Kumar judgment, this 1957 mines minerals development rules have been radically, comprehensively amended. It says, it's a you are holding the natural resources in trust. So government's largesse cannot be distributed in a way you like. So thereafter, all these rules have come into vogue, and 1957 acts were also comprehensively amended after that particular judgment, and 4G spectrum also. That natural resources government holds in trust. So you cannot give government dole and largesse in a way you like, in a whims and fancies manner. So certain rules have to be framed. So thereafter comes one judgment in 2016-14. 2016 4 SCC. 2016 4 SCC. 663 kindly sees what does the Honorable Supreme Court say in this particular matter. That was also with regard to Minor Minerals Act 1957. What does it say? May I just respectfully, my lord, refer to certain paragraphs. My lord, if I may respectfully invite your lordship to paragraph 17. This specifically on the mines and minerals, my lord, point.
Yes.
Para 7, the stand of the appellant was held to be against the earlier High Court's judgment. So and so, my lord, may I respectfully invite your lordship to next page, page 671 of the report. Placita, my lord, A and B. The Honorable Supreme Court is quoting one judgment. In Shukhan Singh versus State of UP, this court has considered the judgment of the Honorable Supreme Court rendered in Deepak Kumar, I was referring to, my lord, as well as judgment of this court in Naran Mishran has held that the basic position in law is that the mere filing of an application, either for the grant of a lease or for the renewal of a lease, does not confer a vested right for the grant or renewal of a lease. An application has to be disposed of on the basis of the rules as a stand on the date of the disposal of the application. This is one proposition that on the date when I am considering an application, on that day, the rules which prevail will be taken into consideration. Now, my lord, kindly comes to my lord. My lord. Paragraph, my lord. 23, my lord. Honorable Supreme Court takes note of a judgment, Hindstone. That is also a very important judgment in the field of mines minerals. And thereafter, my lord, kindly sees paragraph 24, Placitum G. Placitum G, kindly see what does the Honorable Supreme Court say. that no fundamental right, no person has any fundamental right to claim that he should be granted mining lease or prospecting license or permit reconnaissance operation land belong to the government. It is apt to quote, following the statement of Chin number 18 Handsen, the public interest which induced Parliament to make the declaration contained section 2 as naturally to be the paramount consideration in all matters. So, Miller, there is nothing as sort called fundamental right or invested right, whether to grant of lease or renewal or extension, whatever. And in paragraph 25 and 26, kindly this is what the Honorable Supreme Court say. It is further observed in Monet Ispat, promissory estoppel cannot be invoked in abstract. It is on promissory estoppel of the government. And in view of that, we do not find a merit in this approach. So, my lord, here, my lord, this extension, as on date extension, has the rules. If you had to consider 2016 rules, auction rules, and concession rules into consideration. And these are all rules subordinate legislation will have framed in exercise of the power conferred under Section 15 of the Mineral Minerals Development Act 1957. Sand policy of the government of 2021 say that there is no renewal clause. Once you finish off your period, on that day itself the mine or the block vests in the state government. Thereafter again it will go for e-auction. So here, my lord, a lessee with whom a privity of contract subsists as on date, with the clauses that he will abide by all the rules and regulations that are invoked or will come in future from time to time. That lessee is invoking Article 226, thereby claiming that let my extension be taken into consideration and shorts of a representation of the government. You know, my humble submission is submission with deepest of respect and humility, my lord. It is not sustainable because Supreme Court is very clear. There is no such fundamental right or vested in the case of mining of the list concern. So, these are my respectful submissions, and I hope, my lord, this division bench judgment, I could, my lord,
Yes, what is your answer to this that you had, if actually you have disabled yourself?
My lord, may I just take your lordship to this instruction? The issue has become larger than I thought it was. With this instruction, just reads 2 sentences, my lord. If your lordship believes I should go out, your lordship will dismiss my writ petition. Kindly takes this instruction, second paragraph, or I will place the entire instruction, my lord. Kindly gives me 2 minutes. Concerned BLLRO was asked to deliver the possession of the sand block on 15 December 2021. With a memo dated such and such, wherein the writ petitioner was also informed to take over possession. My lord, 2 parts, directed and I requested to take over. Second, as the petitioner did not take over the possession, a reminder was issued on such and such to the concerned BLRO with a memo dated such and such, and the writ petitioner was also requested to take over possession. Again, 2 parts, request to make over, request to take over. My lord, now kindly sees the 3 letters which they have shown and this instruction on the basis of that letters. First letter, my lord, page 2. 15 December 2021 at top right, my lord. This letter has been addressed by one authority to the other, the BLR. Kindly sees the subject and the tenor of the letter. Making over possession with respect to plot number such and such to Triumph Sales. My lord, now the body of the letter. Enclosed, please find here with a copy of the registered mining lease dated such and such, which was executed in 2021 between the government of West Bengal and Triumph Sales. He is requested to make over possession of the leased out area in respect of sand block number such and such to Messrs. Triumph Sales. This is not a letter asking me to take over possession. My lord, should I go and encroach? It's copied.
Later part says.
Yes, my lord. Rate of possession should be sent.
Forward the paragraph at the end.
Yes, my lord. Yes, my lord. Yes, my lord. With a request, yes, my lord.
No. After that, copy forwarded to
Triumph 5.
Yes.
Yes.
No, and 5, you see there is a writing there.
Yes, with a request to take over possession of the sand block and to erect pakka pillars at his own cost for demarcation of boundary.
Now, this letter was forwarded to you by an email at page 3.
My lord, I think the page 3 email is on the next page. Subject to correction. Yes. Because that's an email of December 15, 2021.
Yes, the letter is also of December 15.
Yes. So this was forwarded to me by mail.
This was forwarded to you.
Absolutely.
So you should have also taken steps to take possession.
Yes, my lord. Then I write to the authority that I am not getting possession. My lord, my letter.
This 15 December letter Where is the averment in your writ petition?
My lord, firstly, this letter, whether this was even received by my clients, my lord, I have to
There
take
is an email
instruction.
now.
My lord, the email is there. The email I see, my lord, in the last, there is a email address of mine, which they say is mine, Triumph Sales and Services. My lord, to this, I will have to take instruction whether this email was ever
Mr.
received
Gandhi,
by me.
Then I'll have to invite affidavit.
Yes, my lord, kindly,
Mr.
kindly
Gandhi,
does that.
please
Because if
file
that
your
is the
affidavit,
situation, then it
because
has to.
This factual thing
My
will.
lord, but may I just
Out of purview of
may I
the
may I just say one
holding
thing? My lord, may I just say one thing? I'll file affidavits. I will not, my lord, your lordship has to consider affidavits. My lord, kindly sees the next reminder also, similar reminders made, 2 reminders. In the interregnum, there are undisputedly, I write to them saying I'm not getting possession. Now, my lord, what happens is.
Let them respond to that. letter,
Yes,
please.
yes,
Let
yes.
them
my lord.
respond to
Yes,
that.
keep you.
Because legal.
No, no, ठीक है.
Heard Mr. Karnani, learned advocate, appearing for the
And today my learned friend is giving exception to that. So we just want 635. Yes.
635.
We are 635. We are filing report on affidavit.
Appearing on behalf of the statement of filing the report.
We are filing report on affidavit. My learned friend is filing exception there. I have received the copy today.
Let the matter
Kindly
fixed.
take it on record and fix the date, my lord, thereof.
634 is also waiting and it's already 117. Let us see if we can come back after two.
630.
Once I finish those assigned matters, I'll come back again.
On the possible matters.
Yes.
Only. Not the recording.
বলো না যে দেখবি লর্ডশিপ রেকর্ড
না না দুটোর সময় নেই
না না 2 PM অ্যাসাইনমেন্ট আগে হোক তারপরে আবার পাস হয়ে যাবে। First over after this, after I finish assigned, I'll go back to.
My lord, praying for not today.
An adjournment is prayed for on.
I'm for the respondent.
Likhun, this matter has been assigned to this bench by the Honorable the Acting Chief Justice. Full stop. None appears for the petitioner. Full stop. Let this matter be listed again on January 9, 2026. You are appearing for the bank?
I am for the bank respondent.
The bank is represented. Next.
Divided item number 685 and 686 for the analogous matter. The 685 is filed by the auction purchaser, but the prayer is that they want their money back, and 686 filed by the bank seeking disposal of the district magistrate order. Earlier location what is bench of your lordship direct the affidavit and all are completed. Pleadings are completed. I'm led by Mr. Basu. May I file my affidavit in opposition. And one more thing, the borrower file an addition of party application.
Who is appearing for the petitioner?
Mr. Shuddha Sattva Banerjee is for the borrower, and the Mr. Vikas Ranjan Bhattacharya, senior advocate, appearing for the petitioner in the first matter. Second matter is my matter. We are seeking disposal of the DM application. Affidavits are exchange and complete. Lordship kindly fix the matter any date after the vacation, it can be disposed of. May I file my affidavit in opposition?
Wait, which one is being called on now?
First one, 685 is filed. Ashok Kumar Ghosh, it is filed by the.
Let 685, it is not with, so please wait.
Yes.
প্রথমটা কল করেছেন তো 685?
Yes.
উইথটা কল করবেন না, 685 টা উইথ করে করছেন কেন? এখানে লেখা নেই তো উইথ, আলাদা আলাদা আছে। না না, আপনি 685 ই কল করুন, এক এক করে যান। Yes. 685 order record করুন, none appears for the petitioner. না, আগে লিখুন this matter.
Of the borrower has been dismissed by the TRT. Before that,
both were being taken together.
Yes, both have been taken together.
Then let them come.
Yes.
The petitioner is represented, but the petitioner bank is represented, but the respondents are not. Full stop. You are what happens?
I'm appearing for the petition in this matter. Everything will be same, just my appearance is to be noted.
Your other side has gone.
He was there. He was.
Yes, so I recorded none appears.
If I will serve, will give you a notice that I have appeared afterwards. If you not kindly just that's my appearance, nothing else. 9th of January.
Then I'll take up the matter today if you are there. Bring your other side, I'll take up the matter.
I think they have left. That's right. If just
then let it be as it is.
Okay.
Or you bring them, I'll take up.
Okay.
687, I am for the state lordship.
I am the private respondent, my lord.
None appears for the petitioner. Full stop.
Number 334.
Your Lordship, I'm for the petitioner. I'm for the petitioner.
What happened? Yes.
The other side is not present.
Yes. Not today. Next. Making it not today.
After vacation.
Not today means after vacation.
Wait a minute.
Reporter.
35, my lord, I am for the
Yeah,
petition.
the state
Lord,
respondent.
Mr. Gali was appearing, my lord.
Mr. Galib, no.
My lord, they have filed their report. Lord, we have filed our, want to file our exception.
Lordship, today only in courtroom we have
We
received
have
the
it after the
exception,
vacation. I'm not saying this.
Very well. report গুলো দিন for exception techniques.
My exception, my.
Report in the form of affidavit filed on behalf of the respondent number 5. Very well. Ask somebody to pray for adjournment. None appears for the petitioner. No accommodation is prayed for.
Issued a scheme for providing fund for preparation of house. And initially, it was named Gitanjali, thereafter Banglar Bari, now Malat, Bangla Awas Yojana. The petitioner made representation as they became all are economically weaker section people. But till pursuant to that Malat representation, the video concerned hold an inquiry. And that is not record, but no report has been till date, has been submitted either to the higher authority, that is district magistrate, or to the petitioner. Now, my lord, your lordship kindly.
You have not been granted benefit under the Bangla Awas Yojana.
Yes. Now, my lord, civil
Serve another notice. I am directing them to.
Well, civil petition has been moved before this honorable court, and coordinate bench passed this order. For similar order. Well, let them district magistrate be directed to my lord hold an inquiry afresh, or my lord file a report. Civil petition. This is my lord Justice Sinha, and this is my lord Parthasarathi Chatterjee. So many petition moved before this now. My lord. Now fund is available, my lord, and disbursing to in respect of the other parties. let the DM be directed to consider and hold an inquiry. Long pending matter.
What about the court fees here? In earlier matter, you were directed to pay court fees.
No, this is matter, and another matter, no. But this is matter, after your lordship, we became very poor people. Very poor people, my lord. Because now political, my lord, issues is there, so they are not getting the fund, which they are actually entitled to.
This was Gitanjali EWS housing
Yes,
scheme.
earlier it was Gitanjali. Thereafter, my lord, name has been changed Banglabari. Thereafter, Banglabas Yojana. And that's time
You
to time.
serve a notice on the government leader. I'll pass the same order. Let one notice be served. So it was. I have. Only one list. Until the supplement.
Grateful, my lord.
6.1, I'm appearing on behalf of Union of India. But I couldn't appear, my lord, before.
41.
Just,
What has happened?
just the previous matter, my lord.
Give your name.
Lordship.
Hey. 643. None appears for the petitioner. No accommodation is prayed for. List. Appear on the previous date here. Yes.
Happened, my lord. That one Chandranath Sapu, he was a owner of a big plot of land. The property by inheritance and partition, etc., dwelled upon this one person called Ajay Shankar. He was holding that property, a part of that property. Now, what happened was that property was land was wasted by a notification by the government. That notification he challenged before the LRT. And one order was passed on 13th September 2010, whereby that wasting was set aside and it was directed that the property will be returned back to the petitioners. Now, in the meantime, the state challenged that order. That order is at page 17.
17.
17.
Yes.
Now, my lord, this order was challenged in WPLRT 164 of 2010. This is still pending. This is appearing in the list of Justice Koposaki Bhattacharya's division bench. We have made an application for additional party that is pending. In the meantime, my lord, this order, after this order was passed, my lord, it's still pending. In the meantime, in that property, several buildings have come up. So we had purchased a part of the land and we find that it was a Bill Chas property. It was the inland fisheries walk. But still the buildings are being constructed. We had written a RTI. But if your lordship comes to page 7 of the page 7 of the supplementary affidavit.
7.
But this is the fishery we had written. This was sent. They had received this. And
Page 7. Page 7 of the supplementary.
Supplementary, madam.
Page.
Malad has got that?
Yes.
Malad, what is the nature and character of the land in so and so? If the nature of land is pond or any other type or types of water bodies, then when necessary conversion has been done or not. If there has been conversion of the nature of the land, please provide a copy of the conversion certificate. If there has been conversion, these are the queries which we made and we got the answer at page 12.
Yes.
But RS plot number is part wasted and part leased plot. But the wasting was set aside. Subject plot is a bill mark class and data on conversion is not readily available. Conversion certificate is a RAX copy and is kept with RAX. Data on conversion is not readily available. Information on NSC of Fishery Department is to be sought from the concerned department only. Least portion of the plot reflects Vastu class actor. But the main purpose of setting aside that order was that it was a water body. Now, water body cannot be wasted. On that context itself, the property was returned. And there's an observation by the LRT court, and that order was subject to challenge and it is still pending. Page 248 of the main application, annexure P5.
248.
248. Several letters we had written. Whether conversion was applied or not, no conversion. They are not giving the conversion certificate also, and they are saying it is bill mark chas also.
Very well. Order record করে নি. None appears for the respondents. Full stop.
I missed the brief, my lord. I am praying for accommodation for the day, my lord.
Not today. None appears for the petitioner. Full stop. The state respondent
Pujali, in respect of Pujali police station, Muslim marriage registrar post, my lord, was created on my lord 30th January 2022. But before that, in 2021, one application was made by the private respondent, here respondent number 7, praying for consideration of appointment in that post before creation of the post. And then, my lord, he filed an writ application also. And there, my lord, honorable court was pleased to pass an order directing the authority to consider in accordance with law. In the meantime, my lord, I also, after creation of the post in 2022, I also submitted one application praying for consideration. And then, my lord, my writ application, the both was there. In the meantime, my lord, as per the order was there, in the meantime, 2023, my lord, an advertisement was published in 24th February 2023, inviting application from all eligible candidates. And the private respondent also applied in that fresh selection process which was held in spite of the order of consideration. But when it was the selection process was going on, then the private respondent filed the contempt application. And in the contempt application, then, my lord, in the meantime, my lord, the panel was prepared by the district registrar, and the private respondent was not the first impanel candidate, and I was the third impanel candidate. But panel was not even published. But under the purported threat of contempt, even in the contempt application, order was passed by the honorable court that opportunity to be given to all parties before making any appointment. But whenever the contempt rule was issued and then came, the authority did not disclose the fact that no panel has been published, no hearing was given, it was not disclosed. But in the contempt jurisdiction, as the order was for consideration, and they considered contempt dissolved, contempt rule discharged. I was not party in the writ proceedings. So therefore, my lord, then I filed the review application, and the first impanel candidate, Salman Sheikh, who is the private respondent number 8 herein, he preferred the appeal before the Honorable Chief Justice. Honorable there. But both the Salman Sheikh respondent number 8 also filed the review application. All the applications were taken, and the honorable court apparent what is that on the face of error apparent on the record. So there is as such no error apparent on the record, because, my lord, in the meantime I am coming. So the review application was disposed of, not dismissed, it is written disposed of, and a stay was also granted for 2 weeks. In the meantime, my lord, we could not be able, the Salman Sheikh also had taken some steps, but could not be able to take. Now, my lord, this person has got the appointment. But my lord, what is? Now I am coming to my merit. I have challenged that panel because the DR forwarded the panel, preparing the panel, this person as the second, and Salman Sheikh is the first, and I am the third, which I am also challenging. The IGR, my lord, IGR has recommended this person, my lord, as to be appointed under the threat of contempt. Maybe, but the consideration order is that. My lord, I am coming to the consideration order because the entire consideration order was that on the basis of that this person has passed Alim, Fazil, Sarheja from one madrasa. But my lord, that is the question that madrasa I have taken by RTI, reply from the government that no such madrasa under the government control, and it is under the private trust, and then also it is under the primary standard, pre-primary and primary, and that primary madrasa has issued the certificate for passing Sare Jaha. As per their claim, it is equivalent to Fazil, that is higher secondary. How it will be possible? This, the review court has held that it may not be considered. So now I have challenged this panel. This panel is bad in law and liable to be dismissed. My lord, kindly have a look at the consideration of IGR at page, my lord, 160. And my lord, before that, the panel sent by the 116 is, yes, my lord, that is 114 was the panel sent by the DR, District Registrar, South 24, 114. There, my lord, Salman Sheikh is first, Mizanur Rahman is second, and Rubina Khatun is third. I am not third, my lord, because my practical experience was not considered. Now, my lord, I am coming to the IGR recommendation to the Joint Secretary.
Page?
My lord, page is 121. Entirely on the basis of that. Upon receiving such communication.
121.
121. Upon receiving such communication from the office of the DR, this directorate has further taken into consideration all the material facts and revealed from the adduced documentary evidences submitted by the candidates with their application, and after due consideration of such facts, following observation has been made. My lord, what are the observation? My lord, all three candidates, namely such and such, applied for the post are all residing with the local limits of Pujali police station area, and it apparently seems that they all have acquired sufficient knowledge in Arabic language, but having higher educational qualification. Mohammad Salman Sheikh might have been considered a step ahead in this regard as compared to other two. Again, while thoroughly analyzing other qualifications with regard to having sufficient knowledge in Mohammedan law of marriage and divorce, it seemed that Muhammad Salman Sheikh, though being successful in passing Alim, Fazil and Kamil, that is my lord BA, did not include a subject like fiqh, which specifically deals with the observance of rituals, morals and social legislation, which is not a fact, my lord, I will show, in Islam, as well as economic and political system, and defines Islamic legal system that seeks to interpret and apply the principles of Quran and Hadith to daily life. It covers all aspects of religious observance, being divided into two branches, legal theory and applied law. But Mizanur Rahman Mullah, this is my lord, with regard to Salman Sheikh, my lord, it has been, he does not pass with fiqh, that is. But my lord, from the syllabus of Madhyamik and Ucha Madhyamik, I will show before your lordship that fiqh is a subject. Examination is there. Routine of examination is there. The second observation, my lord. The Mizanur Rahman, which is the private respondent number 7, whose appointment is under challenge, has passed Madrasa Sare Jamil, my lord, within bracket Fajil, examination 2028 with fee as a compulsory subject. Moreover, he seems to have gathered good experience in the matter of Mohammedan marriages and divorces while performing functions as Naib Kaji under MMR Thakurpukur police station.
Read, I have read.
Yes.
Major
Now, my
Rahman Mullah
lord,
was
kindly have a
recommended.
look, my lord, at page 86. Consideration is on the basis that he is qualified Fajil with fiqh, Mohammedan law of marriage. My lord, now kindly have a look at page 86. 86 is the my lord certificate issued by that madrasa. And then, my lord, kindly have a look at page 87. Madrasa Fale Darain. My lord, the 1, 2, 3 is fees to Hidayatun Nahu. That is, my lord, the primary level. And that I will show, my lord, from the website. My lord, 89. It is there, my lord, Urdu term. That is, my lord, 89. It is, my lord, Madrasa Farehe Darain Horakali was established in 1997 and it is managed by the private unaided. It is located in rural areas. It is located in Kultoli block of South 24 Parganas, direct district
What
of
is
West
this
Bengal.
document, madam? What is this document?
This
Page 18.
document is nature is pre-primary, primary state grade.
No, no. What is the source of this document? Where
And
is
website. It is a website.
website of
This institutional website.
website of the institution?
Institution, my lord, Madrasa Farehe Darain Horakali. 89. I am coming, my lord. Yes. And my lord, it is their trust. And other, my lord, 87 is West Bengal Rabiata Madrasi Islamia Arabia. That is, my lord, the trust which is managed and which is to manage and control this madrasa. There, my lord, this status has been given, my lord, fees to Hidayatun Nahu. My lord, I have understood from the persons that it is primary standard. Now, my lord. Yes, that is, my lord, the line. The school is co-educational and it does not have an attached pre-primary section. The school is NA in nature and not using school building and shift school Bengali medium institutions. The school is approachable by all weather. That is, the school is private building, 8 classroom. The classroom is good conditions. That is, my lord, there. Providing midday meal. And there, my lord, I have also taken from the RTI reply from the West Bengal government. That is, my lord, page kindly have, my lord. Bear me for a moment. RTI reply, my lord. Yes, 135. Yes, my lord. I made the application, my lord, RTI, which is at page, my lord, 133. One 33 with reference is directed to provide the following information. One, whether the
Yes, I have read it, madam. Madrasa is not included in the list. No such madrasa is included in the list.
And my lord, that is as per the trust, it is primary. My lord, primary level madrasa has issued the certificate
For higher secondary level.
Fajil, that is higher secondary. And relying on that documents, the recommendation of IGR was made, cancelling the recommendation of DR. And my lord, with regard to, obviously, the Salman Sheikh is the first empanel, I am the third. With regard to my comparison, my lord, I have given, that is, my lord, paragraph 22 perhaps, that I have given the comparison. Yes, my lord, the comparison is at page 19, my lord. a comparative chart of educational qualification. My lord, I admit that Salman Sheikh is, my lord, more qualified, that is BA pass, than me. But I have also BA from the Calcutta University and Arabic as a subject. And my lord, I have the Naib Kaji practical experience, which has been considered by the IGR in case of Mizanur Rahman, that he has the practical experience with regard to work as a Naib Kaji in Thakurpukur PS. I have also working experience. So with consideration of the knowledge of Mohammedan law of marriage, my lord, I am ahead than my lord the Salman Sheikh. So, my lord, now, my lord, the first of all, my lord, I have made also the madrasa as a party, that under which authority I have also prayed for that. They have issued the certificate at page, my lord, there. That
Yes, let me hear the state. Yes, sir.
Lordship, first Lordship, kindly cease the prayer portion, Lordship.
Yes.
And in the nature of the madams directing the state responded to rescind, recall, and cancel the appointment of respondent number 7.
my lord,
The
may
post
I,
of the
my lord, may I
temporary.
pray one indulgence, my lord, one indulgence, my lord, one. My lord, one indulgence before that. My lord, it is for the, because appointment was for the temporary. My lord, my another prayer is that if with this kind of certificate one person is working, then my lord, permanent appointment should be given in the post. Because my lord, temporary cannot go on for a long. And my lord, I have also prayed for the permanent appointment in this permanent post. And with regard to that, I have annexed also order passed by Honorable Justice Mousumi Bhattacharya, which was affirmed by the Honorable Chief Justice Court in respect of Hooghly district. That in this way, temporary appointment should not go for a long time. So, my lord, my humble prayer is that either, my lord, for temporary appointment, the panel may be recasted, or the appointment, if cancelling that, panel may be recasted upon hearing, or, my lord, the order may be passed to issue for the issue the notification for appointment is permanently in this permanent post. This is, my lord, the alternative prayer is there. That is my
Prayer is Lordship to recall and cancel the appointment of respondent number 7,
Yes.
Lordship. In the post of temporary Muslim marriage registrar. Who is respondent number 7? Respondent number 7 is Mizanur Rahman, Lordship. Now, your kindly, I am giving Lordship trouble to kindly come at page 96, Lordship.
Page 96.
Page 96.
96.
This is the letter issued by the Principal Secretary of the Government of West Bengal to Mizanur Rahman, the respondent number 7.
Yes.
In compliance with the solemn order dated such and such, passed in such and such, WP number Mizanur, passed by the Honorable Justice Subhasha Singh Bhattacharya of the Honorable High Court of Calcutta, but subject to outcome of match number such and such, in the matter of Salman Sheikh versus Mizanur Rahman Mullah and others pending before the Honorable High Court Calcutta, the government by virtue of writ conferred by section 3 of Mohammed that means, Lordship, this letter issued in terms of the solemn order passed by the my Lord Justice Subhasha Singh Bhattacharya. Now I am giving you trouble to come to see the order passed by my Lord Justice Bhattacharya. That is at page 84, Your Lordship.
84.
84, page 84.
Yes.
At page 85. However, a perusal and the nature of the order under contempt shows that the alleged contemptor has substantially complied with the order. The name of the petitioner has already been recommended in due course of law and is submitted by the alleged contemptor that it is expected that such approval shall be received within 4 weeks from the date. It is accordingly the route is required to be discharged. However, WPCR 106 of 2023 is discharged and CPN number of assistance is disposed of, keeping on record the communication handed over in the court today by the alleged contemptor. It is expected the approval shall be sent by the Law Department, Government of West Bengal within 4 weeks from date, and thereafter this contemptor shall take immediate step for finalizing the appointment of the petitioner as temporary MMR for the concerned police station. We have appointed this Mizanur Rahman respondent sir in terms of this order, Lordship. We complied with Lordship's order.
What was the original order? Show me that. In respect whereof contempt was passed.
No, 62 don't avoid. Only consider simplicity. 82 and 62.
6, B6. No.
One picture. Right. But a simplicity is there, that is the consideration.
It is page 136. No, that is review.
No, that is review, my lord.
Original order in writ petition, where is that?
That is also the page 84.
Calcutta contempt, my lord, that has been missed.
Original order has not been annexed.
Not in the
Oh,
next.
my lord, and I am-
That orders was.
You have a
passed
copy
on
of that order?
August 21, 2023. That is the
You have a
original
copy
order.
of that order?
Yes, my lord. I had my lord, it was the name. Yeah.
Not there.
Not
No,
there.
it must be.
Passed into WPA number 175.
Very well, the other private respondents are also not there. You bring a copy of that order. That is required.
Yes, my lord, that is, I know, my lord.
Because that becomes the basis.
Basis, it is the order, simple order of simplicity.
Private facie lordship, we complied this order in terms of.
Yes, I will need to see the
my lord,
the
my
main
lord.
order.
Yes, my lord,
The-
it is in the review application, my lord, this is. I will bring it by.
Yes.
But this is my lord.
The review application is not annexed to this.
No, review application, then it will be so.
Yes.
And there is some review.
This was only directing them to
Yes,
cite the representative.
consider. And even, my lord, when the post was not created, I have said that memo number I have stated. How, my lord, whenever the post was not created, he filed and order was also passed.
This
Suppressing
repetition. This repetition.
Petition or suppressing?
Lays challenge.
My lord, I am appearing in this matter for the respondent number 8, my lord, because I am the impanel candidate number 1. But I have been superseded by the respondent authority, particularly.
Very well, that is not your writ petition now. So somebody who has been superseded will not be heard here. The person.
No, I am not on that. My lord, I try to assess your lordship because I am hearing all the proceedings. Because my learned friend.
Very well, on the
who
next
has
day. On the next day, not now. Not this way.
Appointment of respondent number 7 is under challenge.
Yes, 7 is
Yes,
the more important. This writ petition lays challenge to the license dated to a license dated December 28, 2023 issued under Section 3 of the Bengal Mohammedan Marriages and Divorces Registration Act, 1876 in favor of the respondent number 7 inter alia on the ground that the same has been issued on a on the basis of a misleading certificate issued by an institution which was not which did not have authority to issue the same. That is the challenge.
Yes.
Full stop. Paragraph. Learned advocate appears. Service. Full stop. Let a notice be served upon the respondent number 7 intimating the said respondent that
To produce their authority to issue that.
Respondent number 7 na kore, non-appearing respondents kore din.
Yeah, they have also served,
Notice,
yes.
yes. Let a notice be served upon the non-appearing respondents, intimating them that this matter shall be taken up next on 2026. Let them come, then I shall ask them to file affidavit.
Yes.
Affidavit of service filed to
I'm
the Court of Appeal. Next.
When the matter will appear, Your Lordship?
16th.
16th.
16th. So kind of, Your Lordship. So kind.
Okay,
I'm appearing for the respondent number 8.
Please,
So kind of.
Okay, Lordship, I am for the petitioner. Last occasion, Lordship, for the setting up secondary mill, sawmill, and
yes.
Report is. Huh? This one? No. Take it. Please, give them. Copy.
A report has been handed up to the
Just now he is handed up. Just now.
But you consider it come back.
Lordship, these are similar. They have not, the meeting is pending since long.
No. They have taken a decision. They have said they are not approved of for issuing any further license. No. Paragraph 9. Paragraph 9, you see.
Lordship, similar order passed by the Honorable Justice, my Lord Justice Rituvato Mitra, Lordship, to consider this matter. May I hand over this, Lordship?
As per the decision of agenda number 5 pertaining to the issuance of new secondary category license, the 10th SLC as on the date of meeting has not approved further issuance of new secondary license from the list pending application.
May
of
24.
such and such.
So
So 10th
thereafter,
10th SLSC meeting was held on 12th of September 2025.
no, Lordship. 31st May. Yes, that's it.
Where is that? Where is that? Where is that written?
That is pending.
Where is that written? That his application has not been pressed is not written. They say they have not approved further issuance of.
My learned friend placed before the Lordship. And the similar matter was decided by the single bench of our Honorable High Court. Kindly Lordship consider this.
The judgment will not help if the facts of the case are not same.
Same. Lordship, these
They
are
are not same.
Lordship, kindly consider this one for a moment, Lordship. The sawmill matter, Lordship, is similar matter, Lordship. Because the additional government officials have no objection to such. Yeah, because of the matter, this matter is pending since long, Lordship. Till date, they have not taken any.
Page 13.
Since long matter.
Where is the petitioner's application?
That is another more from one. This is not in this matter, Lordship, because this is since 2002 matter. My is application 2025. The similar matter, Lordship, Honorable High Court.
Similar matter, you're saying this 10th of September, where has it been then? This order was passed on 6th of November. This 10th September meeting was not placed before the court.
That's why may consider that. Lordship
So
given
what will
direction
I
to
do with
consider.
by considering this? 10th of September, these minutes were not placed before the court.
They have not given any intimation to me also.
So you were supposed to come back on the next date only. What is the use of this kind of a report, which says one thing and you are making another submission? It will not serve any purpose to the client getting the representation disposed, the writ petition disposed of with consideration of representation if ultimately you are not going to get any benefit. This says you have read paragraph 9 of the report.
Yes, Lord, but it's
You have not read. Please read it.
paragraph 9 of the report.
Has not approved further issuance of new license.
Pending as on date 31st May 2024.
Yes.
Since
So
then,
from there they have not issued. They are not approving. That is the meaning. They have not considered is one thing, not approving is another thing. Try to consider and appreciate.
not approved. Suggestion. Not approved.
Yes. That is some sort of a rejection. He says it has not been considered. You are also saying not considered. This says they are not approved. There are two different things. Not considered and not approved. Approved means considered and not approved.
List of 1056 secondary non-passing. Paragraph 8, Lordship. September 25 for further decision. But after 12 September 2025, they have not given any. They have not till date not taken any instruction as per my information. That's it. Matter is pending. 12 September 2025. Till then, they have not taken any. That is my humble submission before you. Neither consider not dispose of, and I am investor.
Kindly take page 11. You are saying same order, same orders. Take page 11. You have not read the report.
11 of the report. Just now, hand over to me.
So then why are you jumping when I say that there is something else? Please take, see, there is a decision, there is a caption decision. CB. After considering the number of secondary category mills, including these, for which extension of time for issuance of license and approved such and such, has not approved further issuance of new secondary license from the list of pending application. This is the decision.
Up to 31st May.
Pending up to 31st May 2024. And when did you file your application?
Thereafter.
Yes.
My application is 19/12/2020. No, Lordship. Before.
Then
before, Lordship.
That is what it has been rejected, not approved.
But they have not given any intimation to me.
That is a different thing. But then
Lordship, this is my.
he is also not ready. You are also not ready. You should have read this. You are also saying it is pending. It is pending. I would have passed a wrong order. Read the papers.
Just now, I hand over this report to me, Lordship.
You take proper instructions, come back.
Lordship.
Go through it.
Lordship, just
this order will not help.
Just now, I hand over to me. That's why I'm not going to.
I have gone through it. I was indicating to you that there is something wrong in this.
Careful.
report in the form of an affidavit filed on behalf of the respondent number 3 is taken on record. Full stop. The petitioner seeks some time to go through the report. Full stop. When should I keep it? When should I keep it? Next week you'll be able to come back. Next.
Next week also. Why you declare the pending?
As prayed for by the learned advocates, advocate appearing for the respondent. List this matter once again on 9th January 2025.
That's it. Have a happy new year, doctor. 9th January. দিয়ে দিলাম তো।
Yes, record করে নিন. Copy of the report has already been served upon the learned advocate appearing for the petitioner. Copy of the report has been served upon the learned advocate appearing for the petitioner. Next matter is the same thing.
Same lordship, but I am informed to learned advocate for the respondent. State respondent, but
Report is not there, so let the report come.
similar, but
Nobody is there. Time is also not there. Original side matters have to be taken.
then lordship kindly fix on the next 9th January. I am.
It will appear automatically on 9th only. Yes.
Then lordship
Original side.
I just have your lordship's leave to mention item now 655. This is a matter where we had mentioned this matter on Monday for upgradation. Your lordship had allowed this. But there was an urgency that the agriculture season is on, and this is a matter
What is
relating
on?
agricultural season. And I was subjected to social boycott. Your lordship had heard this matter. But if your lordship kindly keeps it on Monday, because I'll be losing my season this time again. Because the social boycott is still on, Malad. And every day, Malad, something or the other is happening, Malad.
Very well. 655.
Yes, Malad.
655 একটু নোট করে নিন তো 655 আজকের লিস্টের you have to inform the other
Yes, definitely, Malad.
It may not be taken up on Monday, maybe on Tuesday.
Malad, I shall.
655 টা আর্জেন্টে রাখতে হবে একটু কথা বলে নেবেন সন্ধ্যাবেলা গিয়ে লিস্ট যখন ফাইনালাইজ করব কিভাবে রাখবো
Grateful.
appellate side original side give it
to mention item number 3, your lordship's original site list, but I was told that item number 2 may go on. Well, I was to file my affidavit. Lordship had directed me to explain why I did not disclose the bank accounts. But I've prepared this affidavit. I've just now served on my learned
so should I take that on record and pass an order then Mr. Banerjee, Mr. Dasgupta, yesterday's those two matters somebody else's name was given. I have not signed the order. Instead of your name, Mr. Rajiv Mollik of somebody else. The same order you said, but the order's date is also different. I have not directed the same order. I have. So therefore, same order it can't go. I have simply adjourned it. Because yes, but I have adjourned it saying it will appear on that date because I have not passed any detailed order. I did not even hear Mr. Banerjee. Yes, that is there because that was an order passed. In the other matter, no order was passed. Only. So therefore there was difference. But even Mr. Banerjee was not even heard. So I have simply adjourned it. Yes, I have said it will appear on 15 January.
But if my affidavit...
You inform Mr. Mollik also about this. He should have told me that you are not appearing because the same order would have been typed.
But if my affidavit could be taken on
If
record...
possible, ask him to come. Yes. Ektu number
item number 3.
Objection means you file an opposition to this if you wish to file. Item number 3 টা একবার কল করে দিন এনাদের ছেড়ে দিন
last time is the last order. So this is again, fourth page from paragraph 12.
Lordship had directed me to explain why the closure of the bank account was not intimated to this court on various occasions when the matter was taken up for consideration. And I've tendered my apology on this. But yes, yes.
Last they had handled what we are
Thick na thick is.
Page 3, paragraph 10 is the order, Director. Likhil.
Pending bureau score, that was, if I'm not wrong, that was the assignment of bureau lawsuit.
This has also been assigned.
That has not been assigned. He, my lord, of his own.
This has been assigned.
Oh, I see, my lord. Yes, previous order is.
Yes.
Then it's.
That is what I was going to
Oh,
dictate.
I see.
This matter has been assigned to this court by the Honorable the Acting Chief Justice. Full stop.
contributing matter, I remember you.
My lord, in this thing, yesterday something has happened very exceptionally, which will send chill to anybody's spine. And certain documents were submitted to your lordship, and a blank certain copies were given to.
I am not taking cognizance also.
But my lord may not be take cognizance this. But what happened was this, that those documents were being I have those two documents I have annexed in this affidavit. My lord, kindly have-
This is going on enlarging this scope of the writ petition. Don't give any factual thing anymore. It's already there.
Yes, no, those two documents were shown that other person has shown multiple. That was document which has been shown and given, and a copy thereof was given to me. I had asked that complete set may be given. He said that no, it won't be given. That two documents were fabricated documents, and
Very well, I'm not taking cognizance of that. So why are you making that issue? I'll not be taking any more affidavit at reply stage, please. No.
Can you have a look at the document? That's all. If a law enforcing agency is submitting a document which is forged and fabricated, well, it may not look into it.
What is the use? I will not be deciding forgery here.
May not be much, but
Then
one exception is to be taken as this, that the invoice which he has shown multi-origin, original invoice which has been filed, there it is India. And the shipping bill says country of origin is state of Tamil Nadu, and that district it is being there. That document is shown before lordship that look, others are complying with this, and I had stated this, that in the shipping bill there is no column where one can put multi-origin, and it is impossible that someone can make a declaration. And in the invoice, if you make a declaration of multi, it will be liable for confiscation, then tribunal law. He said others are showing I am such a such bad person, and he submitted two documents before the court. When he submitted, he gave me a copy of that two documents. When I yesterday after the matter I found out that invoice which was produced before us was a fabricated one. Invoice which has been filed before the customs at Kerala port, and the shipping bill, which was accompanying with that, which I have been able to get.
That is
Those two documents I have annexed. It shows that this invoice, which has under the letter of credit, was the invoice. Country of origin shown that its original, which is filed with custom, is India. Shipping bill mentions all India, but this document T-board was having it. T-board was a custodian of all documents. A law enforcing agency, for the purpose of in anxiety to prove it, starts fabricating document and starts giving fraud. Then this is the end of civilization, which I will say like this, that prosecuting agency fabricates a document, gives at the last moment that this is the document on which I am being guilty, and he says that I will decide his fate ultimately when it comes to me. But and that is what he asked. But in this circumstances, my lord, can you look into it? If necessary, my lord will kindly send it for inquiry. Start a proceeding under 340 of the Criminal Procedure Code. If my lord allows this thing to go, and if my lord ultimately says that no, I am not looking into it, a government agency tendering a fabricated document.
I am not bound to take whatever is tendered to me. I am entitled to refuse. I am refusing to look into it. That liberty I have. That cannot be forced upon me. That whatever you want to show, I have to see. I have to.
That's
relax
correct.
on that.
That's correct. But thing is this: a government authority pushing a fabricated document to clinch a prosecution over me is the thing what's happening. This authority of India submitted a document, the others are complying. That document is fabricated, invoice mentions country of origin India. He is showing multi-origin, etc. He had in his file original document.
He has in his file shipping bill. He is a custodian of that. That shipping bill has is country of origin is Tamil Nadu. It's a, now he is holding those documents in chest and pushing that. My lord
Where is
believes.
who is appearing for
My lord
today?
believes prosecution story because it comes out from the government. There is a presumption of truth when the government speaks up. When the government speaks up that this is the situation, all court will accept it. My lord, if that situation is misused for the purpose of connivance with certain persons who are not disclosing their identity, who are coming to the court without naming, who are they? Person, the legal entity who is coming in the court is not showing whether I am a legal entity who can intervene. A persona can intervene. A persona, it should be either proprietorship or etc. There is no persona, no person, and he claims a right of audience before the court without disclosing who he is. If there is an exporter who is affected, he should come. I am exporter, I am affected. He puts something which doesn't exist. He comes in a burqa. Whatever under the him he is having, I don't know. And these documents must be supplied by these persons only. This can't be done by them. When they got hold of this document, fabricated, which was given to this court, immediately handed over at the last stage when the reply was there. In course of hearing, I was asking him if anybody has been complying with, give me a copy. I have sent it in writing also. He did not reply to this. At the fag end, when my lord said, you answer on two things. One, that judgment of the court that this entire proceeding by you is immaterial, it's not relevant, and it should be quashed entirety of this your function. And second thing was that in the shipping bill there is no drop box word, only that. He came back to the round, started argument. He did not answer any of the two. He says drop box is inapplicable, and he came back to his original argument, what he was making. See that the country is not wholly obtained. If not wholly obtained, it means multi-origin. If it is not wholly obtained, I have given all the B. There is no grievance that I have not said B. When I have said all B, and that is multi-origin, then I have said that. Multi-origin, nobody knows. Multi-origin thing, if you put, no country can process the document. It will go in UK, it will go in other country, document won't be processed because all go by WTO protocol, which they've approved it. In that protocol, it won't go, then it won't be there. So, and if he says, I have fulfilled B, but I have not mentioned this word, that is, he was to answer. He came back to that. Then he also said this, certificate of origin I was issued. That was not by the agency, other agency. Which the point he had not taken in the opposition, which he had taken it. And still now, other agencies are issuing this. When they are issuing the certificate, one copy is sent by wire within 24 hours as per rules to them. They have not objected to it. And here, for the purpose of this, they are saying that this is unauthorized without saying in what I am saying is this. Parties can make allegations against each other, they are free and for the purpose of gain. But when a law enforcing agency makes such kind of false accusations, these things are very different. If my lord takes it up in a manner in which it should be taken, so that this kind of thing must not go any further. In that case, my lord, similar things which has earlier happened at Bombay, place where the person was prosecuted, sentenced jail because a map was planted in his pocket and which was not having blood, but ultimately found in pocket this map of Bombay, and he was on that basis he was linked and was a planted document. Now on the basis of these planted documents they do it. But it is, I would not have minded if any personal person had, government agency would have done it for his own gain. One can do it. There are many persons who are going to jail for the purpose of.
Very well, let Mr. Tiwari be here. He'll answer it.
Yes.
Let
Yes.
me hear Mr. Banerjee.
Yes.
So, Mr. Banerjee, yours is not a trust, or it is a trust. What is it? Because if it is a trust, then in that case,
It is, we have not, I'll be very candid with court.
Mr. Banerjee, we are at one on this, that there is a subtle difference between trust and association of persons. Trust is not an association of persons. Association of persons, if
there is no dispute with it.
if it is a
as they say,
society, there are judgments
item
to
on
that.
that. Add item on that.
There are judgments to that effect. Judgments galore.
I've been able to find out. The association's rules are there. It's an association. That's why I made them. Now the authorization is the individual person is kindly consider the individual person.
It should be authorized by all the members then of the association.
Yes, that is already there. That is already there. The resolution.
That is how we have learned.
Yes,
if it is a trust, correct. Has to be trustees. If it is an association, if it has attained some kind of personality by way of a statutory registration, then in that case, no. Otherwise, writ, no. Suit, no.
I am absolutely not joining issue. That's absolutely correct. There is no question. Second issue or submission on that. That's absolutely correct. Trust, all trustees have to join because the property in that sense rests in the trustees. If it's an association of person, sometimes we have difficulty. I don't know whether knows. In fact, Calcutta Swing Club still continues to be an association of person. Others have all become incorporate companies, all the clubs. So
or you can associations also can maintain writ petitions, provided all the members, or it is espousing a cause of all the members.
That's right.
If it is one of the members, then again individual.
That's right. So here, that's what we have done. We have though the application is in name of the owners association, but we have in the supplementary which we have done, enclosing the notification, you said kindly treat the individual person as making the application on behalf of them, because otherwise there will be no legal representation in that sense. Absolutely correct. Anyway, that's my first submission. Second submission is we are on a larger issue. Today, it's very important. What point my learned friend has raised, I thought, I don't know why he again wanted to submit, but what he has raised in the writ petition, now that we have a copy of the writ petition, I've seen that. The issue what he's trying to raise, which I've understood, I've already heard the matter. This is my little understanding of what I've seen. He says in the Customs Act, there is no such scope.
Yes.
Therefore,
it's his pointed argument that the format in which he is required to put in his shipping bill, that does not have a provision for anything called multi-origin. If he puts in that, the format will not be accepted by the whatever the
that perhaps cannot be an argument if the Customs Act cannot provide.
No,
for...
he says he'll be unable to export. How will he export if he is unable to generate the shipping bill in a format which is acceptable to the technical?
That's not his. In the writ petition, I have not found any evidence that he will not be able to export, because in fact he admits.
No, somewhere I read.
If kindly looks at he says there is no drop down box to say, or there is no column to say. Kindly look at paragraph 7.
Paragraph 29.
29. Look at what he has. Yes. Kindly look at paragraph 29. That's not his. The respondents cannot force the petitioner to use terms contrary to international law. But I'm not concerned.
No, last two lines of paragraph 29, and there is a hint in paragraph 28 also.
Under the Customs Act, under Foreign Trade Development Regulation, the country of origin goods exported by the petitioner shall be India. Mentioning a multi-origin would be unacceptable in international trade. All the petitioners buyers are happy and satisfied. I'm sorry, I do not understand.
Mentioning of multi-origin would be unacceptable in international trade. Kindly take page
paragraph
28.
28. The petitioner said the country of origin cannot be termed and mentioned as multi-origin in the declaration,
And statutory documents to be used in other statutes which control export and import. Foreign countries do have the legislation do not provide in recognition to multi-origin for international trade.
This first 4 lines hints at what he wanted to elaborate.
That is misrepresentation. I am on this. This is exactly what I'm complaining of. You are passing off tea from unknown sources as tea of India. If your trade stops, I'm sorry, you are doing a wrong trade. You are misrepresenting. And that is the concern of the tea board.
So, Mr. Banerjee, will I be wrong if I understand your submission in this way that the petitioner, if he wants to export Indian tea, it has to be only India? If there are several other, a particular state of India will not make it non-Indian.
No, correct.
It will remain Indian. So therefore, the drop-down menu contains the name of the states. If it is a mixture of items from several countries across the world, it becomes multi-origin. Therefore, the moment you mention multi-origin, it will not be exportable as an Indian tea.
Absolutely.
So therefore, multi-origin.
Absolutely. So he is taking advantage of the system to come and say that I'm sorry, if I put multi-origin, it will not be accepted in international trade. That is my case.
Shouldn't be.
Yes, you are taking advantage of the fact that you are getting away by putting Indian origin and exporting your goods. I do not understand. Why should the international trade say refuse something on multi-origin? In fact, then you will be stating the correct thing. You state where it has come from. Africa, which part of Africa, if you want Rwanda, wherever the tea is produced, Sri Lanka. You do not misrepresent by telling international community that it is Indian tea. It is of Indian origin. It is not. That is the misrepresentation. And that is exactly the falsehood which is happening here. So I do not understand. His difficulty is the one which he wants to overcome because he wants to misrepresent. It is not a difficulty. It is an art of hurdle. Yes. It is the art of trade. To make he says someone he earns in crores. 700 or 7,000 crores I saw. This is how he's earning. He's getting cheaper imports from other countries. He's blending it in India. Then he's exporting the whole thing as tea made in India or of Indian tea origin. As we know, I don't know whether it is in that sense a notorious fact for the court to take a recognition of the fact. Indian tea Indian origin has some credibility. So you're using that brand to ensure you make profit. And this notification, which I want to in the second submission, but I'm saying this is very important. Kindly appreciate. You can't come and say that Customs Act doesn't provide for it. Of course, Customs Act is not interested in what you're doing with regard to what marking has to be there in Indian tea. Customs Act is an act which governs the field of imposition of customs duty, what is leviable with regard to goods, which are either being imported or exported. I just want to show you. Kindly just take 3 or 4 paragraphs repetition with me. First paragraph 15, page 6.
1-5.
1-5. Petition has been in the business of exporting tea since last 30 years. Petition has average export turnover rupees 400 crores per year of the last 10 years. You discover a loophole, this is what you do. Then kindly see paragraph 17. Export of Indian tea, 17 page 7. Indian tea mixed with imported tea and blended needs to follow the provisions contained in said order, which the petitioner has been following meticulously. Petitioner, while exporting manufactured tea containing imported tea and indigenous tea, makes declaration of composition, description, and state exported, and after approval, grant of license by the respondents. No, respondent number 2, consignment of tier exported. Then he says first exported, then very interesting, paragraph 19 he comes to country of origin, then he comes with his arguments, 19, 20, where he placed the Customs Act against the Tea Act. And then very interestingly, kindly come to then 21, 22, 23, my lord, I'm not chopping. This must have all been placed before my lord. With regard to my lord, he challenges the power of the keyboard. I'll just show 2 provisions. Then my lord, kindly come to sorry, my lord, I missed paragraph 19, I think, my lord, where it says, I'm so sorry, my lord, I missed paragraph. Yes, 19. I'm so sorry, my lord. I just missed paragraph 19. Page 8.
Yes.
So his knowledge, according to him, my lord, is only on 7th April 2025. He came to court. Why does he come to court? Only on 7th April 2025. After, my lord, this was discovered. Because I'm also making a point. The notification is from 2021. So unless, my lord, is shown cause, he was going on doing, my lord, what he wanted to do. The notification in now, kindly looks at page 42.
This case was notification was never notified.
Yes, well, this is a directive.
Therefore, he since it was never notified, he was unaware of it. So he was.
I do not.
He says that his case is that it was prepared for some reason, manufactured.
This directive. Oh, that Mullah, I did not know that the keyboard Mullah can only.
It shows explicitly this is a manufactured document which has been brought now,
Mullah,
and they are saying
I cannot make any submission on that. But kindly look at page 42. Page 40.
He has no right of order.
Please.
Ask him whether his registration is there or not.
Mullah, how does it? Mullah, this is
That matter. If it is association of person,
the court suo moto can hear me.
No, it is not a public interest.
Court suo moto can hear me.
It is not a public.
If there is a notification which is under challenge or a document under challenge which is going to have ramification on a person who has interest in the business, then he can be heard.
Malad, that what the Supreme Court has said that
why
if the person is aggrieved,
cutting me out?
well, what the judgments of Supreme Court and many other judges who can intervene in a writ proceeding is commercial interest being affected is not a ground for intervening in a proceeding. That is exactly paragraph 33 of the Supreme Court judgment, which I said. In the paragraph 5 of the judgment says that if anybody's commercial interest is infringed, that is not a ground for this.
Answer is point. So that this
Where at 3:30, we have this issue. That's why I wanted to start at 3.
So we'll have to reconvene because this will have to be ended. Because we cannot get along with that. There are 2 judgments cited. You answer those judgments also.
If a copy is given to me, no copy has been.
Mr. Swarkar was indicated the judgments which were cited.
I'll look at the judgment, whatever it says, it's not a question of commercial.
I have not yet added you. I am hearing you.
Yes. On the question of hearing me, can also hear me without adding me also. I can be also allowed to intervene.
I have done that.
Yes.
I have also done that while I was that side. Because before Justice Bhattacharya, it was the same thing. I had also done it and I was heard. A matter went up in appeal also, and
I would imagine that's the law. I would really because that's why I started off saying in a writ petition where he has challenged a notification where I come and show at least I'm showing I am
without an addition of party application.
Yes, I am Tea Owners Association. I am showing he's not denied. He's made points. What? He's not a trust. He's not a registered association. Let us take everything against him. Still, it is a body of owners and manufacturers of tea, which has its own rules. And rules come and say, if the notification is under challenge, I want to say something on this. This is where we stand. If the court thinks that no, I have no interest and cannot be heard, I will not be. But on the face of it, I am showing I am part of this. And why I'll show, kindly look at the notification, page 42. It is given to all producer association, all exporters association, all buyers association. And he says he's an exporter. And only one exporter has come. Only one exporter has come. And his volume of business, apart from that vague statement saying he's made only 400 crores in 10 years by using tea of Indian origin.
Mr. Mehta,
Yes.
at page 16 of the affidavit in opposition also,
Yes.
the email which was sent to all has been sent to the Tea Association of India also. By the tea board.
Page 16
of the affidavit in opposition filed by the
filed by the page 16, page
pa-
70.
page 16.
Page
the
16 is
email sent by the
email in India tea.
Indian Tea, then Tea Association of India.
These are to whom they have sent the intimation. Number of persons are there.
Your name is not there.
Exporter is not there. Relevant custom is not there. In that case, DGFT is not there, and those who are connected with creation of a notification, they are not being.
No, but they have given it to those people who are supposed to comply with it.
But what happened? Even, my lord, an adjudication order is passed, or assessment order is passed. Some notices are issued. A copy is marked to the master copy to the other authority who are concerned with this. If a notification is issued, in that case, to whom it will be served? A copy will be going to notice board. A copy will be going to secretariat. A copy will be going to the other authority. These were the persons who will be served. And under the rules of business, my lord, this is a notification has a procedure. The government can do everything in the procedure.
I'll come back.
This thing which has been created, this mail is not been produced, is not certified. Is not. I have
No, it's on affidavit.
Mail is on affidavit.
Mail, in the reply, I have said this mail is on affidavit but uncertified. And even
Certification is not required. High Court, if it is an affidavit, it is an affidavit by the person. He takes responsibility.
And with this,
Further certification is not.
and with this notification is not annexed. I pointed out. They did not come up like no. This notification was left.
Very well. Yes, Mr. Banerjee.
Well, on the notification, that's what I was showing. I hadn't seen the affidavit. I'm very grateful. In the notification, it also says it's sent to all producers.
No, because in this, I remember Mr. Tiwari had showed me that.
So then, that is. So this question now, I do not understand now that saying it has to be certified. First time I've heard that mail has to be satisfied when it is disposed by the tea board. So this mail, this notification, this directive existed. So a challenge to the directive is also
no directive.
No, it says directive. It itself says.
It is the ministerial proceeding.
It itself says there's a direction. He's also bound by it. Kindly look at the Tea Act and the control order. All this with regard to in the Tea Act, I've made copies, my lord, if it helps.
I have, I have.
And the control order, my lord,
Yes, that is, there is a compilation.
right. Then, my lord, kindly look at, my lord, section 10,
Section 10.
functions of the board. And kindly look at, it shall be duty of the board to promote by such measures as it thinks with the development under the control of the central government of the tea industry. Then, my lord, 2, without prejudice to the generality of the provision subsection 1, the measures referred to herein may provide for. Then, my lord, kindly see, my lord, F, regulating the sale and export of tea. Then, my lord, H, increasing the consumption in India and elsewhere. Registering and licensing of manufacturers, brokers, tea dealers, and persons engaged in the business blending tea. Then, my lord, F, improving the marketing of tea in India and elsewhere. This is, my lord, section 10. And then, my lord, kindly look at, my lord, section 30, subsection 3. Kindly look at, my lord, section 30, subsection. First, my lord, section 30, subsection 1. The central government may, by order notified in the official gazette fixed in respect of tea of any description, specified respect of any description therein, then maximum price and all that. Then, my lord, kindly come to 3, subsection 3. Central government may, by general or special order, then kindly come to C, 3C. Regulate by license, permits, or otherwise the production, storage, transport, or distribution of tea. Then, my lord, 5 is without prejudice to the generality of the powers conferred by subsection 1 and 3, any order made thereunder may provide. Then, for requiring persons engaged in the production, supply, or distribution of, or trade and commerce in tea, to maintain and produce for inspections and books, accounts, records related to business, and to furnish such information, and that for such other matters, particularly in entering and search of premises, vehicles, sunsets, seizure, and all that. Under this, my lord, they have the, my lord, tea control order. I'm going to kindly come to the tea control order. In exercise of the powers conferred by subsection 3 and 5 of subsection 30 of the Tea Act 1953, and in supersession, such and such, this is then, my lord, this is called the tea control order. Tea distribution, tea distribution and export control order 2005. Then, my lord, kindly look at, my lord, definition of 2G. Geographical indication. And then, sorry, before that, my lord, F and G also, my lord, will take. So I'm only showing, my lord, that, and this is for the purpose, my lord, I want to read, my lord, more few rules, my lord, of the control order to show that the Customs Act, my lord, is in a different field. So far as carrying on a business or export of tea is concerned, that's completely within the domain of the Tea Act and any control order issued here. So it is no excuse, and that is what we'll find. That's why I said the theme of his writ petition is, look, I am permitted under Customs Act, and you, the Tea Act, cannot override the Customs Act. We are not on that. Customs Act is on the question of levy of customs when you export import. Tea Act controls the business of import and export of or manufacturing of tea in India. So when you export from India tea, you cannot put, and that's where we come in.
That was the submission of Mr. Tiwari also, precisely.
But, can I get 15 minutes on Monday or not?
You can have it. You can have it, because I don't think it is going to complete before the vacation, the way it is going on.
So this is a very important issue, which is I don't know. I'm sure everyone's argued.
One thing more really is this, that when this fact is not disputed, when I have said in my petition that every week, every day, when assessment orders are being passed by the tea board authorities, then all documents are there where in my invoice it is being mentioned that it is blended with this or is imported tea percentage is given, import percentage, all documents are given, and on that box it is being given country of origin, the box which is required for the purpose of the international law. This is required for the purpose of international law, because there are rules relating to country of origin. Country of origin is not an abstract term. It is being used by the WTO, which is followed by all countries. So in WTO, country of origin has two: wholly produced or not wholly produced. This is all which is there. It will be last processing where it is done. It will be that country, it will be mentioned. And if it is not wholly produced, then business exemptions may not be granted to it. That is what the purpose of the exemptions. Here, no exemptions are available. This is not a question where exemptions are. Had somebody claiming exemption, that he is claiming exemption, by saying this, then in that case, one person is taking advantage. When he is not claiming exemption, he is simply export and he is allowing export. All orders pass. Period of appeal 6 months expired, no appeal, nothing. Even when the writ was filed, not a single certificate of origin or export document has been challenged. Now, what they are arguing, my lords, is something, or what is innocence and ignorance has everything in the world. Person who does not understand the country of origin is what it is. It is country of origin is the last processing done. If I am manufacturing a tea,
these kind of submissions for country of origin, we also understand what is country of origin. We also understand what is misrepresentation. We also understand that.
It is
something. It's a challenge for
regarding the document being. It's very unfortunate that a senior counsel is making it. This is the document which we had got from a third party to show only that country of origin. This is
keep it. I'm not taking cognizance of that. When once Mr. Tiwari comes,
questions have been made.
I have the minutes of our main.
You put it by way of an affidavit, Mr. Put it by way of an affidavit so that it is regularized. Because this defect will remain, it's not going to end here.
Yes.
So Monday. Let us have it after the vacation then, because Mondays will be hard pressed for time now before the vacation immediately. Because there will be pressure of motions, and you are protected by an interim order.
Yes, madam.
So there is no urgency of that sort now.
But thing is, my exports are being very much affected. But what happened when this matter was being taken up by the earlier bench?
Yes.
When these facts were brought to the notice of the court that this is not being notified, then court has, my learned friend will be saying this, was that let me stay the notification. Then he says we will.
Yes, I've seen there is an order passed by the coordinate bench, so that is continuing. You are already protected.
Yes.
I mean, I was minded to complete it, but then
let the same position remain. I have no difficulty. It's okay. But if notification is stayed, it will be better. If notification is stayed,
whatever interim order was passed, I will continue with that only. No fresh.
That is continuing. That is continuing.
That is enough. Heard Mr. Mehta, learned senior advocate appearing for the petitioner. Mr. Banerjee, learned senior advocate appearing for the applicant in GA1 of 2025. And Ms. Singh, Ms. Tiwari, Ms. রয়ে গেছে, খান্নানি রয়ে গেছে।